all delegates and participants in this international conference to switch the microphone into mute mode to avoid any interruption during the conference.
And welcome to all the speakers at International Conference.
The Honorable Rector of Hasanuddin University.
The Honorable, the Dean of Faculty of Law, Hasanuddin University.
The Honorable, all the Dean of Hasanuddin University.
The Honorable, all the Vice Dean of Faculty of Law, Hasanuddin University.
Excellency, a keynote speaker, Mr. Dr. Damos Dumoli Agusman, SHMA, and the Director General for International Law and Treaties of the Ministry of Foreign Affairs of Indonesia. Excellency, Professor Hanim Kamarudin, Ph.D. from University Kebangsaan Malaysia.
Excellency, Professor Topo Santoso, M.Hum, Ph.D. from University of Indonesia.
Excellency, Professor Dr. Eddy Hiariej, M.Hum, from Gadjah Mada University.
Excellency, Mrs. Imelda Deinla, Ph.D. from Australian National University.
Excellency, Professor Dr. Surya Deva from City University of Hong Kong.
Excellency, Mrs. Dr. Khanyisela Moyo from Ulster University.
Excellency, Professor Dr. Dwia SH, from Hasanuddin University.
The Honorable, all the lecturers of Faculty of Law, Hasanuddin University.
The Honorable, all the partners of Faculty of Law, Hasanuddin University.
Excellency, Head of High Court of South Sulawesi.
Excellency, Head of High Prosecutors Office of South Sulawesi.
Excellency, Board of Director of Ikatan Notaris Indonesia or IKANI, Region South Sulawesi.
Excellency, Head of Indonesian Advocates Association, Makassar Branch.
And all distinguished participants of International Conference and invited guests.
Assalamualaikum warahmatullahi wabarakatuh.
Good morning.
Shalom.
Om Swastiastu.
Namo Buddhaya.
First of all, let us pray to Allah Subhanahu wa Ta'ala, the Almighty God, for His mercy, blessings, and guidance, so we are able to attend this international conference on the track, business, human rights, and globalization, organized by the Faculty of Law, Hasanuddin University, with the name Legal Problems in COVID-19 Outbreaks and its Solution.
Ladies and gentlemen, let's sing the national anthem of Indonesia, Song of Indonesia Raya, and will be continued with Universitas Hasanuddin anthem. Ladies and gentlemen, please stand up. Ladies and gentlemen, please be seated.
Ladies and gentlemen, and all guest participants, before we start our opening ceremony this morning, let us pray to God and give thanks for His blessing, so that will be conducted by Taufik Hidayat. For Mr. Taufik Hidayat, please, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, let me read the reading of the best of Islamic Sharia. For ladies and gentlemen who are religious other than Islam, please pray according to their religion and belief. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. حمدا شاكرين حمدا نائمين حمدا يعافي نعمة ويكافي مزيدا. يا ربنا لك الحمد كما ينبغي لجلال وجهك القريب معظم سلطانه. رضيت بالله ربا وبالإسلام دينا وبمحمد نبيا ورسولا. أشهد أن لا إله إلا الله وأشهد أن محمدا رسول الله. لا حول ولا قوة إلا بالله العلي العظيم. Ya Allah, Ya Rahman, Ya Rahim. The most merciful and the most compassionate. Today, we want to hold an international conference on righteousness, human rights, and globalization conceptually. Make every thought and action of all involved acknowledge that benefit to the human nation and country of Indonesia. Ya Allah, Ya Halik, Ya Kudus. Allahumma inna nas'aluka salamatan fid din wa afiyatan fil jasadi wa zayatan fil ilmi wa barakatan fil rizqi wa tawbatan qabla al-maut wa rahmatan inda al-maut wa maghfiratan ba'da al-maut. Rabbana salamna anfusana wa illam taghfir lana wa tarhamna wa lanakunanna minal khasirin. ربنا لا تزغ قلوبنا بعد إذ هديتنا وهب لنا من لدنك رحمة إنك أنت الوهاب. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين. Billahi fi sabilillah fastabiqul khairat. Wassalamualaikum warahmatullahi wabarakatuh.
The Honorable Ladies and Gentlemen, we would like to present to you the art of traditional welcoming dance called Tari Empat Etnis, presented by UKM Seni Tari Hasanuddin University.
Traditional dance of Tari Empat Etnis is choreographed from 4 tribes in South Sulawesi. There are Makassaris, Bugilis, Torajanis, and Mandanis to symbolize life by unity in diversity, so as our dedication to welcome the arrival of girls.
Ladies and gentlemen, enjoy the show.
Give applause for Unhas and Deinla for the beautiful dance.
Ladies and gentlemen, we would like to inform you that this conference live from Baruga Baru di Lopa and virtual through Zoom meeting platform. And also we make sure if this conference held with health protocol, regulation, and we hope all of the participants enjoy the conference.
Ladies and gentlemen, the next agenda is a chairman of organizing committee report for Mr. Dr. Winner Sitorus, SA M.Hum. Please, the floor is yours.
morning.
Good morning.
Assalamualaikum warahmatullahi wabarakatuh. The Honorable Rector of Hasanuddin University, Professor Dr. Dwia Aries Pulubuhu M.A. The Honorable Keynote Speaker, Dr. Hiariej Damos Dumoli Agusman S.M.A., Director General for International Law and Treaties of the Ministry of Foreign Affairs of Indonesia. The Honorable the Dean of the Faculty of Law at the University, Professor Dr. Farida Patiti S.H.M.H. The Honorable Deans of Faculties of Hasanuddin Universities, the Honorable the Vice Deans of Faculty of Law, Hasanuddin University, the Honorable invited speakers, Professor Dr. Surya Deva, Professor Kamarudin Ph.D, Professor Topo Santoso, S.H.M.H. Ph.D, Professor Dr. Eddy Hiariej, M.Hum, Professor Dr. Juajir Sumardi, S.H.M.H, Imelda Deinla, Ph.D, Dr. Khanyisela Moyo. The Honorable all invited guests and all presenters, ladies and gentlemen. First of all, let us give thanks to Almighty God for His blessing and grace, so that we can attend the opening ceremony of the second International Conference on Trade, Business, Human Rights, and Globalization 2020 this morning. In the second conference, we take the theme Legal Problems in COVID-19 Outbreaks and its Solution. We consider this theme that the pandemic has affected many aspects of society's life, including legal matters. Today's conference will be presenting a paper of the keynote speaker and papers of the invited speakers, as well as presenting around 105 papers from 24 universities in Indonesia. And from those papers, selected papers will be published in several international journals indexed by Scopus, approaching indexed by Scopus, one international journal and one accredited national journal. We hope that through this conference, even though it is held virtually by Zoom, we will have a fruitful and exciting discussion and exchange of views and ideas related to the main theme of the conference, and also topics related to the area of trade and business, human rights, investment and dispute settlement, democracy, constitution and globalization, maritime, environment, and international policy, governance, and anti-corruption, as well as general issues. We also hope that this conference may become a medium for strengthening cooperation and networking between all participants and universities. On behalf of the organizing committee, we express our deep gratitude to Rector of Hasanuddin University, the Dean and Vice Deans of the Faculty of Law, Hasanuddin University, for the support and assistance have been given so that this conference can be held today. We also thank the keynote speaker, invited speakers, presenters, participants, and moderators for participating in this conference. Finally, we apologize if there was any inconvenience during this conference due to the committee's invitation. And enjoy the conference, and we look forward to seeing all of you at our next international conference in 2021. Thank you very much.
Thank you for the greetings. The next agenda is greetings and welcoming speech from the Rector of Hasanuddin University, and afterward, we would like to request the Rector of Hasanuddin University to officially open the international conference. For the Mrs. Professor Dwia Aries Pulubuhu, M.A., please, the floor is yours.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone, and praise to Allah Subhanahu wa Taala for the blessing and guidance that making us possible to gather here, even though virtually, to attend this very strategic conference held by Faculty of Law of Hasanuddin University, and praise to our Prophet Muhammad, Nabi Muhammad Sallallahu Alaihi Wasallam. Honorable Director General for International Law and Treaties of the Ministry of Foreign Affairs of Indonesia, Dr. Damos Dumoli Agusman, SHMA, as the keynote speakers for this conference. And I would like to greet also to distinguished invited speakers coming from several universities in Indonesia and abroad. We are very delighted to have you all here, and also including the presenters and my colleagues, vice rectors, dean, especially the host, deans of Faculty of Law of Universitas Hasanuddin, and of course the organizing committee and all faculty members from all university and in Indonesia and abroad, and of course for all participants that joining the international conference, the second international conference on trade, business, and human rights. Trade, business, human rights, and globalization, with bringing the very important topic, legal problem in COVID-19 outbreaks and its solutions. Ladies and gentlemen, I'm very honorable to find it honor to be here to give some words to welcoming you all for this conference. And as we know, there are many issues of human rights and law that can unite us to work together globally. Then we can solve the problem of any violation of human rights and law. Moreover, in the era of Industrial Revolution 4.0, that has opened up space that for us to see every problem of the violation of human rights and the violation of any activity, including trading, business, political agenda, and others that occur in any country, in one country, even a small country, inside the country, that will become a common issue. Even though this is the internal problem, for example, such as practical politics activity that recognized are not in democratic ways done by the local government to marginal communities, that become a big issue, become a major topic to be discussed by international human rights activities or by researchers to become the object of study and become international research to find the root of the problem then of course the result of this study will be the fact-finding to build the micro theories, micro perspective that can be for others place that maybe happen the same cases.
Sorry for this trouble connection.
I'm trying to connect it for the Rector of the University.
Other, then it will become a spotlight. The practitioners, a spotlight by World Trade Organization. What the impact on the World Trade? Gentlemen, this conference by having important topic such as the problem of COVID-19 in and its solution, I think this also very broad issues that ideas because the problem of not only a matter of health but also causes about the employment and also about what about the work rights and also issue of the fairness of the distribution of assistance to the people. Global issue also to me is about and how among the people inside the country as the priority group to be about the issue of hegemony, who will arrange a vaccine production. What about the trading? What about the vaccine? It can be raised by human rights of the law of national business and so on. Gentlemen, I'm very proud to see that our university can conference. To us, this will accelerate in international cooperations with the world university, with the world international researchers, and can have or take to international joint research that can publish together many things that can be benefit of this conference. And gentlemen, to you of love among 10 faculty at Universitas Hasanuddin or productively. The study program that the Faculty of Law Universitas Hasanuddin to be able to expand its international such as international trade law, international maritime affairs, and also that related to protecting the human rights. Ladies and gentlemen, I would like to thanks to all that make possible this conference is undertaken, of course, for the first and for the most, for the Director General that can be will to be the keynote speaker, and for the invited speakers for their times and their concern to join this conference. And I would like to thank also, of course, to the Faculty of Law of Universitas Hasanuddin, especially goes to the organizing committee, and of course the partners that support this event can be experienced. And of course, not to forget, thanks to the all presenters and participants that joined this international conference. And I hope during the discussion, you have a very fruitful discussion and have a very nice academic experience in the conference, even though we make it virtually. And at the last, of course, it is a very honor to me to do as the moderator request to do the opening ceremony, and I will do with a very happy and very delighted. Well, by saying Bismillahirrahmanirrahim, on behalf of Universitas Hasanuddin, the second international conference on trade, business, human rights, and globalization, that bringing the topic on legal problems in COVID-19 outbreaks and its solution, held by Universitas Hasanuddin, Faculty of Law, shall be starting officially. Thank you very much and hope the bless of Allah Subhanahu wa Ta'ala. Thank you. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you for the Rector of Hasanuddin University, the Dean of Faculty of Law Hasanuddin University, and all the Vice Dean of Faculty of Law Hasanuddin University, and Chairman of the Organizing Committee. Thank you so much. Ladies and gentlemen, to capture the moments from activities of this international conference, we would like to take a picture virtual together, and we would like to invite all of the lecturers and committee of the conference to take a place on the stage. And don't forget to keep them space or physical distancing each others. Dr. Damos Dumoli Agusman, Eddy, as the Director General for International Law and Treaties of the Ministry of Foreign Affairs of Indonesia. And this will be led by our moderator, Mr. Dr. Winar Sitorus, M.Hum, as known as a lecturer from Faculty of Law, Hasanuddin University. For Mr. Dr. Winar Sitorus, M.Hum, please, the floor is yours.
Thank you very much, Master of Ceremony. Good morning, everybody. We are very happy this morning to have Dr. Damos Moyo Agusman as a keynote speaker. Before I give the floor to Dr. Damos, I would like to read brief CV of our keynote speaker this morning. Name, Damos Dumoli Agusman. Place and date of birth, Aceh Barat, 4 August 1953. Position, Director General, law, international law and treaties of Ministry of Foreign Affairs of the Republic of Indonesia. We can contact Dr. Damos through HTTP-HRsG and also through Twitter, Damos Agusman. Yeah. Besides working for Ministry of Foreign Affairs, Dr. Damos also as a lecturer at Faculty of Law, Gadjah University, International Law Department. To activate our time, without you, I would like to invite Dr. Damos Moyo Agusman as M.Hum to give his speech. Time is yours.
Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Yang terhormat Ibu Rector, Profesor Dr. Dwia Aries Tina Pulubuhu MA, Ibu Dekan, sahabat saya, Profesor Dr. Farida Pati Tinggi, SH M.Hum, and distinguished speaker, all participants, very good morning. First of all, I'm pleased to be here to address my experience, at least, not my speech. And the organizer informed me to share about the implementations of the trade agreement in the COVID-19 outbreak in this very important conference. As we notice now that we are now under unprecedented times in history, where COVID-19 has changed everything in our life, including our business, and also including the way how the university and public education is conducting the business. So information technology become very important and even crucial now. So we also notice the physical distancing, wearing masks in public, frequent hand washing, working from home, studying from home, like most of us here, and also virtual meeting, such as the one we are having now at this moment. This has now become our new reality. But I'm very impressed when noticing and seeing the dance performance this morning. It's looked like that the pandemic doesn't prevent us to continue our work and to continue our activity. And the shields or the accessories, pandemic accessories, if I may say, does not prevent the dancer to be a beauty and the dancer, the handsome dancer to be look nice. So again, we still survive in these situations, and I'm very much looking forward that we have a new adjustments in the future. But the question is, how does this new reality affect us? I put it more specific. Quo vadis Indonesia trade agreements? And how is the interface between the pandemic and trade agreements globally, regionally, and nationally? In this regard, I would like to briefly speak on several key issues. The first is about the magnitude of the COVID-19 challenges. And then, as Indonesia always in a very strong view that we need urgent cooperations, urgent need for cooperations. And Also, I would like to share about the Indonesia economic diplomacy on the implementations of the trade agreements in the time of COVID-19 pandemic. Let me start by saying that COVID-19 has brought down the international community into a massive global health and economic crisis. As of 9 November 2020, that's the day after yesterday, before yesterday, the virus has infected more than 49.5 million people around the globe and led to the death of more than 1.2 million people and put half of humanity under some form of lockdown, or in Indonesia, in a very moderate way, we call it PSBB. All countries around the world are affected by this pandemic, no question about that. All countries, its impact has caused in all sectors and in all levels of economy. So all forecasts, be it the World Bank, IMF, OECD, has already forecasted that the global economy is expected to contract in the negative range from minus 4.4% to minus 5.2% this year. So this is very unprecedented in our global economy. Unfortunately, the current pandemic takes place in the time when the global environmental conditions are full of uncertainty. So we have already living in the uncertainty global environment, but now it's deeply unfortunate that this pandemic has actually increased the geopolitical tension, where great power collide and compete. So this is also characterizing the current situations, and we are now watching and observing closely the presidential elections in the United States. So we're still not sure where the direction will be if the administrations in the United States has changed from Trump to Biden's, but a lot of scenario still not sure whether we are going to have a better geopolitics or still remain the same. Now, so the question is, what are our options? What the available option now? So we all have to step up concerted effort to pave the way to recovery from health crisis and economic disruption. So this is the key that Indonesia is always pursuing. This pandemic demonstrates the importance of strong three-party cooperation or partnership between government, the research community, and the health industry. So this is the three-party cooperation that we need to enhance. The partnership are essential to bridge gap in health technology between countries, and at the same time to ensure the implementations of international rules and commitments that are reflected, among other, and this is very important, through trade agreement. The question is, why should we care about the implementation of trade agreement? Trade agreements have notably grown in number and deepened in content, and they influence how economics across country integrate, functions, and grow. So this is very relevant because trade agreement can enable the series of stages in the productions of a product or service for sale to consumer. This is called global value chain, or GVC. So the issue of the global value chain is now become very critical under these pandemic situations, because many people is a bit worried about the disruptions of the global value chain. And if you look at how the global value chain works, for example, each stage will add value, and at least 2 stages are in different countries. For example, a bike is assembled in Finland with parts from Italy, Japan, and Indonesia and Malaysia, and is subsequently exported to the Arab Republic of Egypt and its surrounding countries. So this is the way how the global value chains work. And global value chains also advance productions and support innovative manufacture and services, improve efficiency, and results in cheaper and higher quality bicycle for consumer. So this is a very complex network, if I may say. So in view of those, trade agreements can reactivate global value chains, as well as facilitate and encourage as well global accelerations of health as well as economic recovery. Now, in the time of COVID-19 and even beyond, trade agreement can bring economic benefit. The implementations of rules and commitments stipulated in trade agreement will not only help to address the pandemic, but also shape sustainable trade and restore economy. For instance, discipline or compliance on export restrictions, which involve around 300 in force now, and notified to WTO up to 2019, could address more than 2/3, or on average 79% global imports. So again, I would like to say that trade agreements could facilitate and could mitigate the effect produced by the pandemic. Yeah. So we always encourage states to be disciplined and to comply. Yeah. I mean, because there is also a lot of bad signs that in the pandemic, even in the pandemic, state most tend to be more protective, more restrictive in the import and exports mechanism. So this is I think will be counterproductive in our global effort to address the pandemic. So ladies and gentlemen, in the context of Indonesia, maintaining multilateralism, promoting international partnership, and encouraging global norm setting in various forums in the areas of trade and investment, such as in the WTO, G20, ICTB, and UNCITRAL, are of significant importance for Indonesia. Likewise, learning from the experience in the history of pandemic demonstrate how important greater international partnership is in solving the international pandemic problem. So I would rather say what President Jokowi already stated in many occasions, that we cannot save until everybody is safe. This is the logic of the pandemic. So that's why the international partnership is become necessary. Yeah, if I may say, it become a must. Yeah. Therefore, in various multilateral and regional forums, such as the UN, ASEAN, and ASEAN Plus, G20, and non-aligned movement, Indonesia continuously call for the urgent need for harmonizing and effective measures to be taken collectively by countries in order to cope with the pandemic and ensure equitable access to healthcare resources and effective medical products and vaccines, and mitigate the effect of the pandemic on international trade and economic growth, intensify coordinated endeavor to restore economic normality. That's the international, that's my point at the international stage. So what about the national level? At the national level, Indonesia also undertaken numerous measures, both to cope with COVID and at the same time also mitigate the economic impact of the pandemic and thus helping economic recoveries. So maybe all of you already aware about the controversial debate on our current omnibus law, Undang-Undang Cipta Karya, Cipta Kerja. So actually this omnibus law was designed before pandemic. So actually nothing to do with the pandemic situations, but it became relevant to the pandemic because this omnibus law tried not only to mitigate the economic, but also to boosting economic development in Indonesia. But in the same time, suddenly the pandemic came out when the process of the omnibus was taking place. So another issue for coping pandemic is about government use on patent, or what we call it compulsory licensing. So TRIP, for example, provide legal means for compulsory licensing or government use on patents. So it's necessary to protect public health in time of pandemic. Therefore, Indonesia enacted the law number 77 of 2020 concerning procedure for government use on patents. And this is also try to take effective measure by developing countries needed to prevent abuse of patent rights, namely preventing the conduct of technology transfer and perpetuating monopolies. Indonesia is also strengthening its national self-reliance on medicinal raw material. We call it BBO, bahan baku obat, through cooperations and economic agreement. So through bilateral cooperation and agreement in the health sector, we try to encourage the development of national health industry. So it has become timely now to concentrate about the national health industry. Indonesia of the view, of course, that FTA or PTA negotiation should not trade off the flexibility and policy space of the Indonesian government on patents. So to prevent what so-called TRIPS plus. Indonesia also to consider taking local BBO, taking local medicinal raw material, but we call it tingkat komponen dalam negeri. So we make policy to foster government procurement. So this is everybody call it a pragmatic approach. In the time when the WTO potential lawsuit is relatively low, especially in the time of crisis. So the issue of TKDN, tingkat komponen dalam negeri, or I call it a local content of the medicinal raw material, is now become a very hot issue, and we should of course address the issue very carefully, because it's also something to do with WTO rules. And we also have now what so-called national in patent law. We try to make a kind of adjustment, and omnibus law also has already talked about this about the adjustment. So Indonesia intellectual property is now focused on law enforcement and registrations. Thus, it needs to be further focused now on innovation and research that drive the development of national medicine industry. So this is the new issue, if I may say, that coming out during pandemic, that the government now very busy on how to build up the national health industry. Now, the most important questions that now Indonesia looking very carefully is about the access to vaccines in this pandemic. So this is a very important issue, and my foreign minister also very, very progressive and very active in trying to open the access to vaccines, because so far it is the only, not the only, but the main answer to solve about this pandemic. So Indonesia is already opened the door for the national health industry, how to produce and to cooperate with other countries with a view of producing a vaccine, which is now going on, and we hope that soon possible we have already been vaccines for the whole of the population of Indonesia. In view of that, Indonesia already produced the regulations on the public procurement on vaccine, of course, President Regulation number 16 of 2000. I say that we have already the regulations on the procurement, but we are now issue another regulations devoted for the vaccines. That's the President Regulation number 99, 2020. So this is to show that how fast Indonesia try to prepare everything in order to solve the pandemic effect. Now, on the last part, I would like to share effort that has been taken to mitigate impact on the pandemic on trade and economy. So as economic partnership is one of the pillars of economic growth and of development strategy, Indonesia diplomacy is now optimizing the benefit and minimizing the risk. Yeah, I mean optimizing the benefit and minimizing the risk of the trade agreement. So what we are trying to do now is enhancing economic partnership, deliver productive trade deals with as many countries as possible. So in order to open broader market access as for Indonesian goods, services, and investment overseas. So if you look at in the last 3 years, for example, we more look at the African market as a non-traditional market. So that's why a lot of international event being held in the last 3 years with our Africans college business. Yeah. So we also attract foreign direct investment to generate productivity spillover, so such as job creation, and also ensure sustainable benefit to Indonesian economic growth and development. So Indonesia economic diplomacy has also been characterized by various proactive efforts to encourage regional comprehensive economic integrations. So particularly in the form of ASEAN +1 FTA or CEPA. Most recently, and I think all of you already being aware, that Indonesia has been playing a leading role in shaping the RCEP, regional comprehensive economic partnership. This is a mega regional trade agreement that expected to be signed at the end of 2020. We have already finished the legal drafting, the legal scrubbing of the text, and it's ready now. The text is ready to sign by the participating countries. So the following is also there is also various form of Indonesia regional economic partnership. We have in ASEAN. So for example, in ASEAN, we have ASEAN Comprehensive Investment Agreement. We have also ASEAN Framework Agreement on Services. We have ATISA, Trade in Services. We have also ASEAN Trade in Goods, ASEAN Agreement on E-commerce, and also ASEAN Agreement on Medical Device Directive. So beyond ASEAN, we have so-called ASEAN Plus. We have ASEAN Japan, ASEAN Hong Kong, ASEAN Australia and New Zealand, and ASEAN China FTA, and also ASEAN Korea FTA. So on bilateral, it's very interesting. We have also a lot of bilateral. We have Japan, EFTA, Chile, Australia, Pakistan, and Mozambique. So recently, we have already concluded agreements with Australia. So I would like to inform you that Indonesia-Australia CEPA, to my understanding, is the most progressive FTA that we have had. So this is the most, if I may say, the most, not the most liberal, but the most progressive and wider cooperation that we have with Australia. And we have also we are also now going to negotiate the same agreement with European Union, Turkey, and also South Korea. Now we are also a lot of now agreement on the table. So the foreign ministry is now very busy, of course, with the Ministry of Trade in preparing this. And this is also the moment, this is also the significant policy endorsed by President Jokowi, that now the foreign policy should focus on the economic diplomacy. Of course, we are still taking care of the geopolitics, and something like that, but emphasize, especially in the last 6 years, we focus very much on the bilateral negotiations with foreign countries. So this is the busiest, if I may say, the very busiest time with my office, how to deal with this kind of bilateral tax agreement, which is so complicated, so technical, and even so complex that sometimes it's not very easy for the diplomats to deal with this kind of technical issue. But we should, of course, deal with that. Thus, trade agreement, we understand, can serve as economic tools to achieve national economic goal. And this is also to overseas business of Indonesia companies that can support the Indonesian business companies. And we also believe that trade agreements can promote trans-border business between and among Indonesian companies and companies from foreign countries, and they can also protect the interests of the companies. And of course, the trade agreement can provide global market for Indonesia goods, services, investment, and this is also the goal. It is, of course, the main objective. The health and economic crisis has deeply interrupted Indonesia, as the crisis threatened a contractions in the range of -1.5% to -3%. So therefore, in Indonesia now, highly in the agenda that reform, creative adjustment, and the utilization of trade agreement can help to mitigate the impact of the pandemic. So we very much rely that trade agreement and of course creative adjustment and national law building adjustments in turn we believe can restore Indonesia economy. So ladies and gentlemen, these are just some of my thoughts on the issue related to trade agreement in the time of COVID-19 pandemic, and we hope that we can survive, and we hope also that next year we have already rebound to the right directions. So the support from the academic institution, the support and input from the international seminar like this one, of course, is very important for the Indonesian government. So Indonesia need a lot of inspiring input, and also need academic research, and also Indonesia should be enlightened with the current development, which perhaps we cannot see, but the university or academic institution can clearly see the problem. So this is the partnership that we would like to build up between the governments and the university. So I would like to thank the Faculty of Law, Hasanuddin University, who is very active in this very important conference. And I do hope that this conference will continue in the future. First, second, of course, the third conference. And Indonesia government, especially the Ministry of Foreign Affairs, is very delighted to be engaged in this international conference. So I look forward to the outcome of the conference and invite us all to learn from one another in the exchange of best practice. So I wish you all have a successful and fruitful discussions. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Dr. Damos, Moyo, Agusman, and for your nice presentation. Do we still have time for discussion? Dr. Damos?
It's up to the organizers.
Okay, because according to the timetable, it is scheduled, your presentation is scheduled until 9:30.
9:30, yeah, okay.
Yeah.
So if time is limited, you can also request inquiry or everything through email or through my secretaries. The foreign minister will be very happy to address that.
Can we have answer the question for 5 minutes, sir?
No problem. Okay, we are ready to depart that.
Thank you. All the participants, if you have any question, you can ask directly, or you can use chat room in Zoom. Is there any question? Is there any question? Sorry, yeah. the unmute mode not activated yet. Okay. All participants, if you have anything to discuss, please you can ask directly or you can use chat. Bro. Okay. There is a question from Fadil. Okay, you can ask directly to Bapak Dr. Damos. Okay, Ibu Fadila, you can activate your speaker.
Assalamualaikum. Assalamualaikum. Assalamualaikum warahmatullahi wabarakatuh. Dear Mr. Damos, I have a question. You said previously about the recent Indonesian treaty with Australia, and you said it's very progressive. Could you please explain a little bit more? What is the difference between the previous FTA or agreements with the current one that we make with Australia, sir? That's all my questions. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Can I directly answer or?
Yes, sir. You can answer directly.
Okay, good. Okay, I think because there is a technical problem, I'll try to be quick on this question. This is a very important question. There are a lot of progressive provisions in Indonesia, Australia, FTA compared to the previous FTA. I only take one example. Perhaps it will interest you. Market access, for example, on the services. Now the University of Hasanuddin can open the university in Australia. I mean, it's now open. So if you want, for example, the University of Hasanuddin want to set up the university in Australia, you can do so. So this is the progressive one that on services that we can we have with Australia. Of course, there's a lot of components which is more progressive. Besides market access, we have also international cooperations and commitment level of commitments. It also lower compared to other agreement. I don't want to talk a lot about that, but you can see in the text of the agreements that's already made public now. So of course, this is we encourage the public and university to discuss about this, because the implementations will be very, very interesting at the end. Yeah? Because it is not, it is a very complex, it's not easy text, it is a very complex one. So we should prepare for these agreements. Thank you, Mr. Moderator.
Thank you very much, Mr. Dr. Damos, for the answer. Is there any other question?
May I ask a question?
Okay, you can ask directly to the president.
Hello, my name is Maria Agnes. I am from the University of Patimura in Ambon. Thank you for the presentation. I think it was very interesting. I have a query to make. As Indonesia is cooperating with many countries through trade agreements, how can we ensure that with these trade agreements and opening up markets, that we can make sure that the cooperation to ensure these vaccines for Indonesia, as it is the main goal for Indonesia right now to obtain a vaccine for its country, how can we make sure that these trade agreements can also accommodate the interests of Indonesia, but also the interests of countries? Because I think there's lots of vaccine nationalism happening, and even if the cooperation with Australia is progressive, we see that Australia also has interests that they have done through pre-purchase agreements with like various vaccine pharmaceutical companies. But how do we make sure that it is with that cooperation that Indonesia can also cooperate to obtain that vaccine, but also these countries will also be able to uphold their interests? I'm really interested in hearing your opinion on that.
Thank you very much for your question. Maria Agnes from Patimura University. Now I'm yours, Mr. Dr. Damos.
Okay, thank you. This is a very good questions. Actually, the logic of FTA or trade agreement is open market. So the market is open for the world. That's the logic of the trade agreement. So the pandemic situations, if I may say, the pandemic situations tend to push state to be more protectionism, to be more protective, to be more, if I may say, look after their own fate rather than tend to cooperate each other. This is Indonesia is very much concerned, but this is also very natural. So, for example, during the pandemic, when the pandemic break up, yeah, what happened to the world? They closed the border. Yeah. They closed the airports, and they prevent foreigners from coming in. So this is the natural instinct of states when dealing with this pandemic. So it may happen to trade and services. It could happen. Yeah. I mean, states try to isolate themselves. So this is why Indonesia very much campaigns about access to vaccines. So we don't want, for example, state with their high capacity in producing vaccine, yeah, try to protect the vaccines from being used by other countries. So this is of course against the trade agreement itself. So what we are trying to, what I'm going to say here is the trade agreement, the logic of trade agreement will facilitate about the access to vaccines if we are very much disciplined or comply to the trade agreement. But again, because the pandemic is a kind of a new situations that unprecedented before, yeah, we still a bit confused about whether we should be protective or whether we should open and something like that. So even in Indonesia, for example, we are still thinking how to make sure or how to secure, not under the framework of the trade agreement, but under the framework of bilateral cooperations. So we go to China, we go to India, and then also we go to UK only for the sake of how to secure access to vaccines. And we also go to WHO, try to have a global cooperations on vaccines. So again, theoretically, the logic of FTA, the logic of trade agreement, supposed to be secure the access to vaccines. So this is the key point that Indonesia is now pursuing. That's why in the next round of the negotiations on the FTA, even PTA, we are also dealing with this kind of the questions. So that's perhaps can help you with your questions. Thank you, Pak Moderator.
Thank you very much, Mr. Dr. Damos. Can we have one more question? Okay, Professor Marcel. Time is yours, sir.
Belum di-unmute, Pak Marcel.
Prof. Marcel, please activate your speaker. Prof. Marcel, you haven't activated your speaker.
Prof. Marcel, di-unmute Prof. Marcel. Please unmute yourself.
Belum keluar, Pak Marcel.
Okay.
Ya,
Okay.
ya sudah.
The honorable all the participants, especially the honorable Mr. Damos and the honorable Director, Professor Dwia Aristina, and the honorable the Dean of the Faculty of Law, Professor Dr. Farida Patitinggi. In Bali province, there is a regulation of Bali Governor number 97, year 2018. This regulation regarding restriction of used plastic at the same time has been implemented since 2019, especially since the Constitutional Court refused any judicial review to the governor regulation proposed by a domestic non-governmental organization or LSM. The background of the issue of the governor regulation in 2018 has a close relationship with the right of everyone to enjoy a good and healthy and sustainable environment as an integral part of human rights stipulated in our Constitution and variable legislations such as laws on human rights, laws on preservation and protection of life environment. I want to submit the question. How to connect or bridge the restriction of plastic use at the same time regulation and international trade liberalization based on WTO agreement. That is all, Mr. Damos. Many thanks I express. Thank you very much for your kind attention. That's all.
Thank you very much, Professor, for your question. Now, time is yours, Mr. Dr. Damos, to answer.
Thank you very much. I cannot hear the whole question by Professor Marcel, but I can at least get the point about the relationship or the restrictions of plastic and the WTO regulations. So perhaps I try to address these questions. Of course, there are a lot of things. I mean, WTO rule is not rules that we can understand about the rules in the law or undang-undang. WTO rules is a kind of permissible rules rather than prohibition rules. So even, for example, there is a kind of activity in the national level which look like violate the WTO rules, at least they can fix that through what they call it trade negotiations, trade measure, or counter measure, and something like that. So there is a kind of mechanisms when some consider that there is look like violating the WTO rules. But on the plastic restrictions, I think there is a kind of environmental argument behind that. So it could be fixed, for example, by the understanding among states that the campaigns on the basis of environmental law, on the basis of global concerns, is a kind of exception, of course, can be not negotiated, but can be put as a kind of what we call it as circumstances under national law that may be permissible under WTO rules. So there's a mechanism on that. So again, the plastic waste is now become a very serious problem on environments, and Indonesia is also very much now doing a lot of things in order to address the situations. And I remember when I go to the supermarket, Indomark, or to the mall, plastic bag is no longer available. And this is also a very good kind of measure, a kind of restrictions, if you may call it restrictions. Yeah. Again, if I may say, we should look at case per case. Until now, there is no country bring up the case to the WTO about the restriction in Bali, as you mentioned. I'm not very aware about the situations about the issue in Bali, but at least no country already raised the questions, and perhaps it could be what we call it. It could be managed in a way that it is still permissible under WTO rules. But we must look at the merits, of course. I'm not very aware about the detail about the issue. Thank you, Pak Moderator.
Thank you very much, Mr. Dr. Damos. And due to limited time, we should end this session. And on behalf of the organizing committee, we would like to thank Mr. Dr. Hiariej Dumoli for your willingness to be a keynote speaker in this conference. As a thanks expression, let me give big applause to Mr. Dr. Damos. Thank you very much. I return back to stage to Mr. Surya.
Thank you for Mr. Dr. Winarsto's design, Mr. Moderator for this session, and also for our speaker, Dr. Damos Agusman, for the example presentation. Your Excellencies, ladies and gentlemen, now we come back to the next session. Our speakers is Professor Dr. Surya Deva from School of Law, CE University of Hong. And the second speakers will be from Professor Dr. Gadjah S.A.M.H from Hasanuddin University. And we will be led by our moderator, Mrs. Dr. Deinla S.A.M.H, as well as the lecturers from Faculty of Law, Hasanuddin University. And the session will be start after the. Thank you.
MC for today. The honorable speakers, distinguished guests, ladies and gentlemen, good morning from Makassar. Welcome to the second International Conference on Trade, Business, Human Rights and Globalization, ICTB-HRsG, Faculty of Law, Hasanuddin University. I am Dirka Latif. It is my pleasure to be as the moderator for this second plenary session. First of all, may I briefly introduce to you all our speakers today. Firstly, I will welcome Professor Surya Deva. Hello, Professor Surya Deva. Professor. Professor Surya Deva, he is an associate professor at the School of Law of City University of Hong Kong and a member of the UN Working Group on Business and Human Rights. Professor Deva's primary research interest in business and human rights, India, China, constitutional law, and sustainable development. He has published extensively in these areas and has advised the UN bodies, governments, multinational corporations, and civil society organizations on matters related to the business and human rights. Furthermore, he is one of the founding editors-in-chief of the Business and Human Rights Journal and become as the editorial or advisory board of the Netherlands Quarterly of Human Rights, the Vienna Journal on International Constitutional Law, the Indian Law Review, and the Australian Journal of Human Rights. Professor Deva is an elected member of the Executive Committee of the International Association of Constitutional Law. And then I will introduce our second speaker, Professor Gadjah who already present in our room in here. He is a professor in International Law Department, Hasanuddin University, with majoring on International Economic Law, become an expert in several of Indonesian institutions, such as Director of Cellular Express Air, Chairman on the Center of Intellectual Property Rights, Unhas 2002 till 2010, legal consultant at the Makassar branch of the State Savings Bank, South and West Sulawesi Bank, expert staff to the governor and the provincial government of South Sulawesi, become also as a regional company advisor for South Sulawesi Province 2007 and 2009. Professor Sumardi, also a chairman of the committee for monitoring the implementation of regional autonomy in South Sulawesi Province. Moreover, he is also become as the expert in the Constitutional Code regarding judicial review, the GR of Law Number 22 of year 2001 concerning oil and gas submitted by the Pertamina Workers Union. Actively in research, local and national, and also speaker regarding his expertise. And of course, as a member of Hasanuddin University and have a possibility with Professor Deva in here, we welcoming if there is in the future any opportunity to enhance joint collaboration for research or other activities regarding issues of economy. Now, I will hold my breath after reading the long of this curriculum vitae from these honorable speakers. Thank you. I would remind both of the speakers that each of the speakers will spend about 15 minutes for the presentation. And after that, we will open the question and answer session for about 30 minutes. So, the honorable speakers, distinguished guests, ladies and gentlemen, without any further ado, again, please welcome Professor Surya Deva. Professor Surya Deva, the time is yours.
Thank you very much. A very good morning to everyone. I hope you can hear me. If someone can confirm this.
Yes, clearly.
Thank you very much. So thank you very much once again for the kind invitation. It's really a great opportunity to interact like this. COVID has, of course, created many difficult times for all of us, but it has also created opportunities like this where we can interact with each other through technologies. So I'm really grateful for this opportunity. So in my presentation, I'm going to focus on two aspects. I would highlight the challenges that are there in the intersection of trade, business, human rights, and globalization, because these are the four terms that are there in the title of this conference. So I would like to highlight, to begin with, four key challenges related to each of these four terms. And then I will mention some way forward in terms of solutions, what we can do in future to overcome these challenges. And then I look forward to some interactive dialogue. Now, the first word in the title is that I want to focus is globalization. I think COVID-19 has shown that the globalization that we have is very fragile. It is fragile for a number of reasons. It is fragile because it is not benefiting everyone. In this world, there are tremendous amount of inequalities. We have rise of populism and nationalism across the world. Supply chains have been disrupted by the COVID. Then we have situations where people are not sensitive to the differences, and we are imposing our views on everyone. And that creates tensions and conflict. So because of these number of regions, it is becoming very clear that the current model of globalization is not really working. This model is also problematic in a way because it is not giving enough attention to the human dignity aspect. I give one simple example to explain this point. It is much easier for products and services to move across the globe. But if human beings would like to move around, it's more difficult. And to me, that shows that products are more important than the people. And I think that is something we would need to fix if this globalization has to be sustained. Otherwise, there will be some serious consequences in my view. That's my first point in terms of the challenges. My second point is that the trade that we have, the international trade that we have at this particular point of time is not sustainable. It is not sustainable because a huge number of people, millions of, hundreds of millions of people are still living below poverty. Economic inequalities are rampant, not only in certain countries, but all over the world in almost in every country. So this trade is not really creating a sustainable world or sustainable society, an inclusive society. And the impact on the environment and the climate are very much visible. And if we do not address these impacts, then I think it is very likely that this trade, the global trade, and the whole idea of interconnected world is again going to be seriously disrupted going forward. The third challenge that I would like to highlight is that businesses all over the world continue to focus on profit more. They put profit before people. They put profit before planet. And I think there is nothing wrong with the idea of making profit. And if businesses make profit, that may also promote human rights because they can innovate, they can create more jobs, and that will definitely help the livelihood of many people. But if profit is the sole driving force for businesses, then it is very likely people and the planet components are likely to be ignored. And then we have a very difficult situation because shareholder primacy could be the dominating force and businesses continue to outsource their responsibilities in the supply chains. So in supply chains, what happens, all of us should know that there is a huge amount of exploitation of the workers at the bottom of the pyramid. Of course, they're getting some opportunities to work, and perhaps they are better off that they are able to work. But who is benefiting from this exploitation? Who is able to buy the cheap goods and products? And what about the remuneration and compensation that the top executives in these big multinational companies are getting? So I think that is a serious challenge that we face, that we do not really have businesses which are operating in a socially responsible manner. And the fourth and the final challenge that I would like to highlight is that human rights, the idea of human rights, despite tremendous progress that we have made in the last 60, 70 years, or the UN system of 75 years, we still have a situation that human rights are not really taken seriously by the governments. And whether these are democratic governments or these are non-democratic governments, everywhere there are serious challenges. And I will just highlight two aspects of it. One is that many governments are putting economic development first, and they think that we should grow fast. And a fast growth is what we need, and we can take care of the human rights, we can take care of the climate change, we can take care of the environmental issues later. And I think this is highly problematic because this model of development is not human rights based. It is not benefiting everyone. The second component of this challenge, why human rights are not taken seriously, is this, that states continue to be selective about the idea of human rights. The idea of human rights being universal, interdependent, and interlinked is not pursued in a holistic manner, which basically means that in some countries, the civil political rights are getting more attention. On the other hand, in some other countries, the economic and social rights are getting more attention. But we cannot have this either or mindset. Rather, all human rights are equally relevant. Of course, the local context is relevant, but we cannot ignore any rights and we cannot put certain rights on the back burner. I think that is the last challenge that I would like to mention. Now, after highlighting the challenges, let me give some suggestions in terms of the way forward. And as you may recall, there is a lot of conversation about building back better, that COVID-19 has created a crisis, and then we can use this crisis as an opportunity to build back better. Everyone is talking about building back better. Now, what does this really mean? And who needs to do what in this particular context? So I agree that we need to build back better, but how do we do it? I have 5 suggestions in this particular point, and I will finish with those 5 suggestions. My first point is that we need to create a human rights based model of development. The current model of development that we pursue, I'm not talking about any particular country, but generally all over the world, is not in line with the human rights based approaches. Of course, we have right to development, which is also a human right. But this right to development does not mean that only some people can develop and others are left behind. The digital divide is again exposed because of COVID. So children who do not have access to computers and good internet speed they are being deprived of right to education. This is a significant issue. And that's where the model of development has to be inclusive. It has to be bottom up. Often we see that development projects are approved in the capitals, whether these are the country capitals or the provincial capitals of different states or countries. There is not enough consultation with the local communities. Do they really want a coal power plant? And who is going to benefit from that electricity? Who will get it? Those are the issues we should be asking. And of course, we also need to consider whether this development model is sustainable. Is it going to be self-sufficient to sustain the future generations? Or are we going to exhaust the planetary boundaries during this particular time, and that the future generations will suffer? So I think my first suggestion is that we need to create a model of development which is based on the human rights. And if we do not take this into account, then I think we are likely to continue the challenges in future as well. My second point is about policy coherence. One issue that we often see is that the governments, different ministries of a particular government, they are not really adopting a holistic and coherent approach. And we see this in the context of trade and investment on the one hand and human rights on the other hand. So when the trade agreements are negotiated, when investment agreements are negotiated, we often ignore issues about human rights, environment, and climate change. Rather, the focus is on attracting more and more investment, increasing the trade output. And I think that is nothing wrong with that, but I think we need to adopt an approach which is sustainable and which is holistic. We should consider how trade can impact positively the realization of sustainable development goals. The idea of SDGs is leaving no one behind. But the current model of trade is, of course, leaving millions of people behind. So unless we reorient the current model of trade and adopt a policy coherence there, I think I continue to see challenges in this particular context. My third suggestion is that the governance has to improve. The governance both at the national level, and I would say that will include, of course, different levels within any one particular country. But at the same time, the governance has to also improve at the regional level and at the international level. So at all these three levels, national, regional, and international level, we need to improve the idea of governance. And here, governance is not merely about the government. It is also about other non-state based institutions that need to improve. That will include universities, that will include businesses, that will include unions and investors alliances and civil society organizations. Everyone would have to come together and create a model of governance, of taking a decision-making process which is more democratic and inclusive. If we look at the data all over the world, certain sections of society, whether these are women or indigenous communities or persons of disability or migrant workers, they continue to suffer. And they suffer because their voices are not getting enough attention in their democratic processes. So there is a huge issue of democratic deficits. The other related issue is about weak rule of law. Unless rule of law is strengthened, we will continue to have those issues about governance. Corruption remains a critical challenge all over the world. So we need to deal with corruption. Transparency is absolutely critical. Access to information is vital. And we need to hold the people who are corrupt accountable, whether these are the government officials or these are corporate officials or these are anyone. At the same time, we need to create more space for civil society actors and human rights defenders. Because ultimately, the idea of governance is that all of us have a stake in the decision-making process. And that is where the role of academics and universities is also very vital. We should maintain our autonomy and independence, and we should be able to objectively articulate and give constructive suggestions to the different governance institutions. And we should not shy away from criticizing the governments when we need to do that. My fourth suggestion is that we need to redefine the purpose of business. Historically, businesses, corporations were created as a social institution. They were supposed to benefit not only the shareholders, but the entire society. And somehow that idea has been lost. And now businesses are becoming mostly to benefit the shareholders. They are putting profit before people and planet. And that's where I would suggest that we should have this idea of profit with principles. Businesses should make profit, but they should make it with the principles. And here I would suggest that human rights should be the non-negotiable precondition of doing business anywhere in the world. And human rights are labor rights, are environmental rights, as well as other issues that are very much relevant, whether these are anti-corruption issues, issues about climate change, issues about gender equality. All these issues are absolutely vital. And there are increasing standards in this particular field. And I will just make a reference to UN Guiding Principles on Business and Human Rights, which provide under part of Pillar 2 that all businesses operating anywhere should respect human rights, which are internationally recognized human rights. How can they do that? They are expected to conduct human rights due diligence and minimize, preempt, and address the adverse impact of their business operations on people, on the communities. We also need to develop, in my view, legally binding standards for businesses. And when the standards already exist, we need to enforce them more strongly. As you may know, there is a process going on at the international level in the Human Rights Council to negotiate a legally binding instrument to obligate businesses to respect human rights. And Indonesian government is supporting that process as well. But in the meantime, we do not know whether we will have this international binding instrument adopted or not. In the meantime, the government should more robustly adopt and implement the legal frameworks at the national level. They should also implement the UN guiding principles so that businesses take human rights seriously. So human rights are not merely about the governments. Human rights are about each one of us. We have to respect human rights, businesses have to respect human rights, and of course, governments have to respect human rights. My last suggestion as a way forward is accountability. And I think we have a serious issue of lack of accountability of those who are violating human rights, whether these are the government officials or these are business executives. Because the focus of this conference is on business human rights, so I'm going to focus on the accountability of businesses. I think it is absolutely critical that companies that exploit labor in the supply chain, companies that pollute the environment, companies that are destroying the forest, companies which are doing illegal things of different nature, whether it's money laundering or corruption, companies which are indulging in human trafficking, companies which are indulging in child prostitution and benefiting from it. You know, the range of issues that we have to deal with. And every country is different, so every country has to see what are the key challenges. But there have to be some accountability of these both companies as well as their officials. And there are a number of means to provide access to remedy in those particular situations. In addition to the judicial system that we have, we also need to rely on non-judicial bodies like national human rights institutions. And I think they could be very effective in providing remedies in certain situations. Moreover, we should also encourage businesses to establish some kinds of grievance mechanism. So if any consumer has any complaint, any issue about a particular company behavior, then they should be able to address it at the local level. Of course, if that fails, then non-judicial systems and judicial systems should step in and provide remedies. So I think these are the 5 suggestions in my view. This is not an exhaustive list, but I think these 5 suggestions in my view should be part of building back better. And if we do not listen to this wake-up call thrown to us by COVID-19, I think we might be worse off in future. The other crises may come, whether it is climate change that might come before us, whether it is artificial intelligence and automation, the 4th generation technology as we know them. Challenges will keep on coming. So if we do not address the challenges and create a more inclusive and sustainable society, I think we will not be better off. So with these remarks, I will conclude, and I'll be happy to take any questions towards the end. Thank you once again for this opportunity. Thank you.
Thank you very much for Professor Surya Deva. I am taking notes about the standard of business, all stakeholders, company, investor, and the decision makers to achieving the sustainable development. Thank you for an interesting presentation. Now we move on to Professor Dwia Sumardi. The floor is yours.
Thank you, moderator. Mrs. Dr. Birkalati, SALLM. I would like to present my presentation. I focus on state sovereignty in international contract on oil and gas management cooperation, an overview of Indonesia practices. I will share screen my PowerPoint. Okay, we starting about my presentation on state sovereignty in international contract on oil and gas management, an overview of Indonesia practices. I will starting about the introduction, my paper. As we know that oil and gas are strategic natural resources for the survival of the nation state. This is the potential strategy of oil and gas resources. And naturally, oil and gas is a non-renewable energy. So that we cannot renewable this material, oil and gas. The characteristic of oil and gas industry are high risk. The first characteristic is high risk, high technology, and high capital. And to change it, the potential of oil and gas resources into real asset, it is necessary to carry out exploration and exploitation. And the problem is almost most developing countries has not available technology and capital. So that there are problems about the state sovereignty. In this case, the state will cooperative relationship on oil and gas management through international contract with IOC, International Oil Companies. So the legal issue, we know that oil and gas management operation that carry out between state and private sector begin with a concession system and then developed toward a contractual system. And each type of operation on oil and gas management has consequences for energy sovereignty and energy security of a country. And state control over oil and gas in each state of the corporation has different one another. And the main question is, what is the position of state sovereignty in international contract on gas, on oil and gas management corporation? This is the main question of our discussion today. My research question, there are three, research question. The first question is how the state control over oil and gas management corporation. And the second question is it possible if a state energy sovereignty be degraded by international contract on oil and gas management? And the third question is how Indonesia should respond to energy sovereignty over oil and natural gas based on Article 33, Paragraph 2 and Paragraph 3 on the 1945 Constitution of the Republic of Indonesia. Let's move the next item. How the state control over oil and gas management corporation. The cooperation between government of the country, in this case, host country government, and foreign companies, in this case, international oil company, on oil and gas industry is generally determined by contract who are negotiated between them. In practice, state control existence, in this case, host country position to oil and gas management will be influenced by its chosen cooperation form. This is the consequences about the state sovereignty will be influenced by the shape of cooperation. In international practice, we find there are four types of cooperation of oil and gas management. The first type is concession agreement, and the second type is joint venture contract, and the third type is production sharing agreement, and the fourth type is service contract. I will explain about the characteristic each type of the contract in oil and gas management cooperation. Concession agreement. The characteristic of concession agreement, in concession agreement, the legal position of foreign oil company, the legal position of oil companies as the owner of the oil and natural gas they manage. So that the host country not the owner. International oil company has control right over all management activities that they carry out and bearing the risk of the losses incurred. And this type generally used by the developing countries from 1940 to 1950. Then joint venture contract. What about the content of joint venture contract, especially its characteristic of joint venture contract? Joint venture contract basically is a participation agreement in oil and gas management. Joint venture contract are an amendment to the concession type. This is the amendment type of concession agreement. And the existence of joint venture contract show a rational reaction and a struggle of the host country to live more profitable in oil and gas management operation. Then production sharing agreement. In international oil company, in this type, international oil companies mandated to provide technology. To provide technology, to provide capital and services to carry out exploration and exploitation activities of oil and gas reserves in the work area agreed by the host country. International oil company has fully responsible for management and has complete control over production operation. And there are options whereby national oil company can participate in different aspects of the exploration and exploitation process. And production sharing contract places the position of the state as the owner, not like concession agreement, but the position of the host country as the owner of oil and gas, but international oil company are allowed to carry out its management for development of oil and gas field in their working areas. And last type, service contract. We know about the service contract. This type is favorable for Nordic. There are two types of service contract, namely race service contract, and the second is pure service contract. Race service contract and pure service contract. Both race service contract and pure service contract, the position of international oil company are to provide services and know-how and to supply the required materials. This is the position of international oil company. In the race service contract, international oil company will be paid only if the international oil company succeeds in producing oil and gas without any access to the ongoing production service process. And the pure service contract guarantees that international oil company will receive a certain amount of remuneration whether they are in production or not. No risk at the exploration state are borne by the international oil company, the government and national oil company bear the full burden of risk. This is the characteristic of the service contract type in international cooperation on oil and gas management. This is the comparison of ownership, control, and risk on concession agreement and production sharing agreement. We can see in this table about the ownership, international oil company. This is the type of concession agreement, yes, and host country, no. Ownership and control full by international oil company, but host state no control. The risk full by the international oil company, but the host state no risk. Only receive the royalty and the revenue of tax, use land tax and maybe the revenue tax in this case. Okay, I continue. Comparison of ownership, control, and risk in service contract operation. This is the table about the comparison, the characteristic, its type of cooperation in international oil company. In the practice, international oil company always use of stabilization clauses. What is the stabilization clauses? In this case, international oil company wish to minimize political risk, administrative risk, and legal change risk in host country. International oil company intensify the imposition of the international minimum standard protection, and the international oil company wish to enforce of the pacta sunt servanda principle against the host country. And international oil company carry out a risk minimized strategy by building stabilization clause in international contract. Is it possible a state energy sovereignty be degraded by international contract on oil and gas management? This is the main and the vital question, I think. Energy sovereignty can be defined as the ability of a country to have the power of control to regulate and to manage its energy. The Charter of the United Nations emphasizes that equal sovereignty for every country, and there is a doctrine of economic sovereignty to claim permanent sovereignty over the natural resources, and the doctrine of permanent sovereignty over natural resources already admitted by the international law, and energy sovereignty in international law in international contract become fixed and permanent, so that cannot be eliminated by the use of stabilization clause in international contract. How Indonesia should respond to energy sovereignty over oil and gas resources? We know that based on doctrine of permanent sovereignty over natural resources that admitted by international law, so that every state has permanent control to exploration and exploitation of activities on oil and gas carried out in its territory. For Indonesia, the concept of control by the state philosophically in line with the spirit of Article 33, Paragraph 2 and Paragraph 3 of the 1945 Constitution of the Republic of Indonesia. And the aim of state control over its oil and gas management basically is to create national energy security for prosperity of all Indonesian people. This is the legal standing of oil and gas management for Indonesia. And the sovereignty theory adopted by Indonesia adopted the people sovereignty theory and the law sovereignty theory stipulated in the Constitution of Indonesia country. And energy sovereignty stipulated to the 1940 Constitution of Republic of Indonesia. And this is the existing condition of oil and gas management in Indonesia. We can know about this condition that state control oil and gas production process is limited by the operation contract in Indonesia. And this is made of US and other countries ownership of the oil and gas working area in Indonesia. We can see here almost most activities in upstream oil and gas organized by the international oil company. And this is position of multinational corporation and Pertamina as a state-owned corporation. Pertamina, this is the red, only only 15% from the total exploitation of oil and gas in Indonesia. And existing condition of oil gas management in Indonesia, we know that Pertamina only can exploit approximately 15 until 20%, and what should be done by Indonesia? Indonesia must enforce implement the substance contained in Article 33, Paragraph 2 and Paragraph 3 of the 1940 Constitution of the Republic Indonesia, and the government does not extend to contract on oil and gas management operation after its validity period end and turn over the management of oil and gas to the state-owned company. In this case, is Pertamina. And Indonesia must make amendment and update to the law number 22 of 2001 concerning oil and gas, with region Pertamina as the country's representative in cooperating of oil and gas management. And this is the my struggle when I proposed the demand to our government, to stop the international contract on oil and gas in Block Mahakam, Mahakam Block and Rokan Block. I lead the demonstration in Jakarta, and this is demonstration to save Mahakam Block, and this is I proclaim Indonesia oil and gas sovereignty in Jakarta. And conclusion, my conclusion in my presentation, oil and gas management has high value and contribution for the greatest prosperity of the people. Therefore, oil and gas management must be controlled by the state. International contract on oil and gas management cannot eliminate the existence of energy sovereignty owned by each state. Therefore, the position of countries' energy sovereignty over international contract is permanent. This is reinforced by the recognition of international law on the principle of permanent sovereignty over natural resources. And for Indonesia, the principle of control by the state is philosophically in line with the spirit of Article 33, Paragraph 2 and Paragraph 3 of the Constitution of Republic Indonesia. And at the end, energy sovereignty is a crystallization of the ability a state to have the power control, regulate and manage the energy it has. And every form of cooperation contract in oil and gas management involving international oil company must place the state in a dominant position. Thank you, and I give the time to moderator.
Thank you so much, Professor Sumari, for the presentation. I'm also taking a notes about his presentation about the pivotal resources such as oil need to be controlled by the state and used as much as possible for prosperity and welfare of the people without neglecting the future generation needs. I know that everybody, the audience already has any questions in their minds, but before I'm opening the Q&A session, I want to inform the audience to state the name, the origin of the institution, and to whom the question is addressed, and be directly into the point of the question, please. So I'm opening the question and answer portion of the session. Please, we will start from the audience. If there is a audience want to ask, you can also put the raise hand feature in your laptops on your Zoom account. Or you can also just directly unmute your microphone and give us your name. Okay, we already have, Detania started. Please, hello.
Oh, halo Mbak Birka. Can I post my question?
To give the question to Professor Deva or Professor Sumati?
I want to pose my question to Professor Surya Deva. Hello, Professor. I would like to refer to what you mentioned about profit with principles. I would like to know what your take on corporate social responsibility, whether it's a tool to achieve that. And for your information, in case that you haven't known, that Indonesia is the first country to regulate CSR as a mandatory practice based on our company law. And countries like India, for example, even went further by stipulating the specific allocation that you need to spend for your CSR. And this kind of policy was highly criticized when it was first enacted because it allows company to do greenwashing to do greenwashing and escape their like legal liabilities. So I would like to know what your take on CSR, whether it's a means or a tool to achieve what you mentioned as profit with principles. Thank you.
Thank you, Detania, for the questions. But I want to ask our honorable speakers before we doing the answering section. Do we have to collect the question first, and then we can move after that to answer that together in the last? Professor Deva and Professor.
Yeah, that's okay. Whatever you prefer, whatever my colleague Professor Somriti prefer. I'm fine either way.
Thank you, Professor Deva. And to our audience, is there anyone who want to ask the question also? Okay, yeah. Okay, we move to Paskun. Yeah.
Thank you so much.
We need the microphone.
I would like to ask my question to Prof. Deva, please.
Sorry, I cannot hear. If this question is for me, I cannot hear this.
Yes, we are using our microphone now.
Yeah, Prof. Deva, based on your expertise in the area of business and human rights, and I saw how this business and human rights has really a good connection right now, and then become an interesting issue, of course. But I saw the connection between both of them in terms of the academic purpose, in the university level still to be improved or socialized. So that's why, based on your experience in your university, how both business and human rights can be merged in one subject, especially because this is very important for us as the good lesson learned, for example. Because in Indonesia, I show between business and human rights, they are segregated, they are separated and then we don't have any subject who merge of them in one subject. So what I mean, when we talk about the human rights in one side and business in one side, but nowadays we're really aware that both of them should be work together because there are so many issues and then so many problems. So how both of them link one to the another. So that's my question actually based on your experience as the expert of this business and human rights in university and in the world. Thank you so much. I return to the moderator. Thank you.
Thank you, Pak Dr. Maskun. And we still have one slot for a question. Is anyone from audience wanna join to this session? I will open the chat. Okay, there is from Hasbi. Hello Hasbi, are you still on Zoom room now? You wanna just
Miss Birka, can I have a question?
wait, we still there's one question from Hasbi. Or maybe I will read the question. So the question about to Professor Sumadi, what do you think, Prof, about the legislation on omnibus bill on job creation? Is there impact of this regulation to our management in oil and gas sovereignty? And the last one is from Rivera, right? Yeah. Who's the one to ask? Yeah, Rivera, you want to I can get the microphone and get to give your question?
Yes, I would like to ask for Prof. Gadjah about the use of the new energy. Like as we know, in this era, we need to find the alternative energy because we know that the oil and gas has the limitation. So I would like to ask, according to you, Prof, did that new energy can get the same treatment, especially when these countries operate in the terms of fulfilling their energy? And also the second one, is it possible that the contract of this the use of this new energy could become a threat for the sovereignty? That's all that I want to ask you, Prof. Thank you, Bu Birkah.
Thank you, Emma. Posting the Q&A, and then that we want to go to our honorable speaker for questions that already be collected. First of all, I will go to Professor Deva. The question from Deinla and also from Dr. Westwood. Professor Deva, do you got the question clearly?
I think so. I will try. Thank you, moderator, and thank you for excellent questions. So the first question was about CSR, whether CSR could be part of profit with principles. And I'm aware of Article 74 of the Indonesian Companies Act, which talks about the environmental and social responsibility of oil and gas companies. So I'm aware of that, but there could be other provisions, I don't know. But at least I'm aware of this Article 74 in the Indonesian companies law. And in fact, I teach that in my class of business and human rights because I teach in a comparative way what is happening in different countries. In my view, CSR cannot be part of my idea of profit with principles. The difficulty is that CSR is often about how you spend your profit. So a company may make millions of dollars in profit by polluting the river and environment, by displacing thousands of people, and then it can spend something on opening schools and hospitals and providing other facilities. Now, there is nothing wrong with that. But this is not the idea of profit with principles. Profit with principles means how you make profit should be consistent with the idea of human rights. So it's not after that you make profit, you donate something. So I think there's a difference. So CSR is not the solution going forward. We need, of course, CSR as well. But before we go to CSR, we also need to ensure that businesses respect human rights. And when I say human rights, it will include labor rights as well as environmental rights as part of doing business and making profit itself. And I think the same difficulty is there with the 2% CSR spending in India. So I think that is also problematic because a company may pollute a river in India and then they can donate the profit to open a school somewhere else. So the pollution remains. And that school is a good idea and people will benefit, students will benefit, but it does not really fix the problem of pollution. So I think that cannot work. And that is where the business and human rights come into picture, that the whole business operation should internalize the idea of socially responsible conduct. Now, the second question was about how to bring business and human rights together. How do we teach them together? If you email me, I can provide you some more guidance, because I have been teaching this course at my law school since 2007, and there are many, many universities in the world where they are teaching a course on business and human rights together. I have two suggestions. One suggestion is that you can integrate business and human rights into different courses. When you teach constitutional law, when you teach company law, you can bring in the idea of human rights in those classes. That is one way of doing it. The second is that universities can start a new elective course on business and human rights, where they can bring in all these elements of Companies Act, Contract Act, law of tort, constitutional law, international environmental law, anti-corruption, human rights law, everything together, trade and investment issues all together. Like, for instance, my fellow panelist, Professor Sumardi, he made an excellent presentation about oil and gas companies and the energy sovereignty issues, energy security issues. I completely agree with his points, but I would go further. The government should have this control, I agree, but the government should also ensure that these oil contracts do not pollute the environment. Otherwise, the whole Indonesians will not benefit. So I think that is the extension we need to see. We cannot have compartments. So there is one compartment of promoting trade and investment, and the second compartment is about human rights. We need to break these compartments. And I think one way to break this compartment is to bring these ideas together in a course at a university. And then we can do that as part of policy making and research as well. Thank you.
Thank you, Professor Devas, for your answering. And then, reminding of the time, I will directly going to the Professor Sumardi.
Thank you very much, moderator. I try to answer about the question about the position of international contract for oil and gas management cooperation. The first part, if we want to know about the position of international contract, we must know about the fundamental principle in international contract law. As we know that one the fundamental principle in international contract law is the international contract law recognize about the supremacy of domestic law. So the international contract cannot may not contrary with the national law of the parties. When the international contract is contrary and conflict with the national law of the parties, so that the international contract has in Indonesia is cacat juridiis, or in legally this point. This is the position of international contract, because in international contract law we know about the fundamental principle. The international contract law recognize about the supremacy of domestic law of the parties. And we know that Mr. Hasbi asked about the omnibus law. In omnibus law, the law governing about the oil and gas management too. But the governing on oil and gas management, I find out in omnibus law will strengthen the function of SKK Migas. In this case, is Special Task Force Unit on Oil and Gas Company. This is very dangerous, because Special Task Unit on Oil and Gas is not corporation. This is the part of government. And the part of government making contract with the business, and the consequences, the government will bear the liability when the contract is default. I think this is my answer to question for me. Thank you, moderator.
Thank you so much, Professor Sumardi, for the answering the questions. And after this like to express my grateful thank you to our honorable speakers for their amazing and enlightened presentation that has been given to us. I will conclude this second plenary session with three quotes. The first one, the connection between human rights, gender equality, socio-economic development, and peace is increasingly apparent from Mahnas Afkami. The second quote is, a community is a democratic only when the humblest and the weakest person can enjoy the highest civil, economic, and social rights that the biggest and most powerful possesses. From Philip Randolph. And the last one quotes from the SDGs, no one left behind. Thank you so much for the honorable speakers. Again, distinguished guests, ladies and gentlemen, may I thank you for your active participation in this session. I hope that you will enjoy the whole program of the second ICTB-HRsG from faculty Unhas, and then I handed the next program to the Master of Ceremony. Thank you. Thank you.
Thank you very much. Thank you. Thank you,
Professor
everyone. Bye-bye.
Professor Sumadis.
Thank you. Bye-bye.
Stay healthy, everyone. Thank you.
Thank you for the presentation. Your Excellencies, ladies and gentlemen, now we come back to the plenary session, and our first speaker is Professor Hasanuddin, Ph.D. from University Kebangsaan Malaysia, and the second speaker will be Imelda Deinla, Ph.D. from Australian National University, and will be led by our moderator, Mr. Zulfan Hakim SH M.Ha, as known as the lecturer from Faculty of Law of Hasanuddin University. For Mr. Zulfan Hakim SH M.Ha, please, the floor is yours.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. We are here for the second plenary session of the International Conference on Trade, Business, Human Rights, and Globalization, held by the Faculty of Law, Hasanuddin University, Makassar. We are pleased to inform that our first speaker for this session, Mrs. Imelda Deinla, Ph.D. from Australian National University, are already with us today. But for your information, it's very unfortunately we have to announce that Professor Hasanuddin won't be available for question and answer session because he has some activity during this time. So maybe only for this session we have only one speaker. It is Professor Imelda Deinla, Ph.D. from Australian National University, and allow me to read some of her qualification here. Mrs. Imelda Deinla, Ph.D. is a fellow at the School of Regulation and Global Governance at the Australian National University. She works on the intersection of law and politics, focused on rule of law and democracy, and on legal pluralism, women, and hybrid justice in post-conflict. She is the author of the book, The Development of the Rule of Law in ASEAN, the State and Regional Integration Coup, 2017, and co-editor of the volume from Aquino to Duterte, Change, Continuity, or Rupture. Imelda also completes the Masters in Criminology, Justice and Regulation program at the Australian National University. She served as the inaugural project director of the Australian National University of Philippines Project and research and policy initiative between the ANU and the Department of Foreign Affairs on track to strengthen bilateral linkage and to conduct evidence-based research of the Philippines' political, economic, and security concerns. Mrs. Imelda also obtained her law and political science degree from the University of the Philippines and postgraduate degree from the University of New South Wales. So at this opportunity of this conference today, Ms. Deinla will have a presentation that this title, why should we look for and build the rule of law in all corners? So with all due respect, my Ms. Deinla, the floor is yours, please.
Thank you, everyone. Thank you for the very nice presentation, introduction. It's really an honor to be invited for this conference. And I also would like to thank my former classmate at the University of New South Wales, Muscon, for this invitation. I'm really excited to be here. So my presentation for today would be brief. It's titled, Why Should We Look for and Build the Rule of Law in All Corners? There are 4 parts to my presentation. One is to discuss about conventional ideas about the rule of law, populism and the rule of law. Number 3, use of bad and good laws or the Constitution to undermine the rule of law. And then lastly, to discuss some possibilities on where to look for and ensure the rule of law. So the conventional ideas of the rule of law. The historical and philosophical genesis of the rule of law came side by side with nation-state formation. In this, law was conceived as a means to claim monopoly of power over large swathes of land and exercise legitimate violence over the population it controls. With wise rulers becoming rarer and despotic, unbound and arbitrary rulers become the norm. Law has been conceived to precisely limit state power. Hence, the function of the rule of law has come to be known as constraint to arbitrary exercise of state power. Constitutionalism is a necessary offshoot of the rule of law, which specifies and provides for mechanisms on how power could be exercised, who could exercise them, how power could be restrained when needed. Constitutionalism, normally expressed in the Constitution, also guarantees the protection of individual and collective rights and ensure that laws and institutions protect these rights. Principles of legal clarity, predictability, stability, transparency, prospective laws, and that laws are written have become the gold standard by which the rule of law should be measured or judged. Human rights have come to be divorced from the rule of law, which are necessary complement in preventing arbitrary rule. However, in many non-Western countries, the development of the rule of law did not follow this linear pattern. As we observe in contemporary times in Western and non-Western countries, the rule of law has vacillated or fluctuated between these constraining and enabling functions. One of the often overlooked historical fact is that formal laws in Africa, Asia, and Latin America have been used to install colonialism to divide and rule the population. We have seen that in the policy of dual laws in Indonesia under Dutch rule, and colonial laws in the Philippines under American and Spanish rule. Pre-colonial structures and culture have also tended to be hierarchical through class, status, or race of people. This enduring problem or vice of unbound and arbitrary power or use of such power to kill, oppress, discriminate, or divide people is true in the past as in the present. And the need to address, constrain, and prevent this so-called brute force is as needed in the past as in the present if we want our societies to be free of violence, fear, injustice, and inequality. Populism is an antithesis to the rule of law. At least this is a common feature among populist leaders who shun limits to their power. Populist leaders claim to represent the true aspirations of the people. Example, whether Trump's Make America Great Again or Duterte's Change is Coming rhetoric. In most cases, they actually exploit and manipulate these sentiments or even magnify the extent of the problems to justify use of excessive force, to defy limits to their power and popularity. Look at what Trump is currently doing in his cohorts, but also the Philippines' war on drugs are examples of this. As well as to reorganize political and legal structures to maintain their hold on power. We can see that in Orbán of Hungary or Bolsonaro of Brazil. Populism is also antithetical to democracy. That is, after they have been elected through democratic processes, they attack democracy and all its values. They will only sound Democrats again when they seek a fresh mandate and to legitimate their authority. In fact, populism is anti many things, including disdain for women and especially women leadership. Thanks to COVID-19, the onslaught of populism is being arrested if the US elections is an indication. The inept performance of misogynistic populist leadership has been exposed and contrasted with how compassionate and caring leadership could bring about to relieve people from the impact of the pandemic and to give hope. Classic examples of this are Jacinda Ardern of New Zealand and Angela Merkel of Germany. The formal and legalistic ideal of the rule of law assumes that with constitution, laws, and institutions, we can achieve the rule of law. But bad laws have been crafted in both authoritarian or democratic times, although we can say that making of bad laws has been a bit restrained under democracies, especially when most of democratic controls are working. So let us hope that the democratic controls are still working in the US and ensure an orderly transition of presidency. The more worrying trend, however, is the use of good laws and the democratic constitution to undermine the rule of law. So we have in our midst the populists, which deploy both undemocratic and democratic tools to give them unchecked authority. In the Philippines, impeachment proceeding and quo warranto have been used to unseat or discredit leaders of independent accountability institutions, such as the Supreme Court, Commission on Elections, and the Ombudsman. The use of these constitutional instruments not only give populists the cloak of legitimacy of their actions, these also give them ample power to ensure their longevity or perpetuity in power, and also further undermine democracy and the rule of law and all the bad consequences it could bring, such as amplifying differences and hatred towards others, fomenting social cleavages and conflicts, and using more force and violence in solving social problems. So where do we look for and ensure the rule of law? So where do we look for and ensure that the rule of law remains a fundamental precept of governing and governance? If we could not turn to the Constitution and to good laws, how do we confront bad laws and bad leadership? As we all know, power is not engendered by laws alone. The history of many countries in Southeast Asia is replete with struggles by the people of enlightened civil society that can fight against bad leadership or encourage and support the good ones. I have always argued that a signal from the public in its strong support for judicial autonomy in critical areas enables the courts to decide judiciously and independently. Supporting and ensuring an independent media is critical to the survival of democracy and the rule of law. So for example, investigative journalism has exposed corruption in the courts and of the informal networks that expose collusion of private businesses, government officials, and military. Having knowledge of and utilize these informal networks is also extremely useful in exposing the cloak of legitimacy, but also for advocacies and generating support from the public. As I learned from an Indonesian scholar, Herianto, having qualities of judicial leadership in court leadership could also make the difference in navigating complex power relationship between the courts and the executive. So I think I have to end my brief presentation here, and I welcome your questions from here on.
Okay, thank you, Ms. Imelda and Deinla. We have already listened to the presentation. Maybe it's brief, but it is a very complete findings that okay. So we will continue to question and answer directly because we are very sorry to inform that Professor Hasanuddin will be available for presentation, paper presentation today because he has one thing in crossing time with our conference. So we would like the audience to directly address your question to Mrs. Imelda. Maybe for the first session, I will regulate for 3 questions. Maybe anybody has any questions? So please. Maybe somebody any question from the floor? Maybe please state your name for the record. Any question from the audience? Please.
Thank you, Ms. Imelda, for the very good presentation. Actually, because although it's not really my specific.
Would you please your name first?
Oh yeah, sorry. My name is Fadila from Hasanuddin University. I have a question. I don't know whether it's really related to the rule of law because I don't really get the concept, but I'm curious. We know that during the pandemic, so many countries like Australia, for example, conducting lockdown or restricted the people who is entering and going out from a country, and some other country making this policy. Do you think that this kind of policy is related to the rule of law and whether this kind of restriction is against the international law of freedom of movement, and what is the relations of this policy with the rule of law itself? Thank you, Ms. Imelda.
If I understand your question correctly, I think you are asking about whether this strict regulation issued during emergency during these times of the pandemic is actually compliant with the rule of law. Is that the question?
Yes, that is the question.
Yeah. So for me, like rule of law has the history of also rule of law is that it also has taken a lot of exceptions, and exceptions to that are emergency power when the state actually has to exercise huge authority in order to address certain critical issues. So, for example, in the Philippine case, in the Constitution, there is an exception, which is the imposition of martial law in cases of a rebellion, insurrection, or other critical, events that require a strong exercise of state power. Pandemic is also an exception in the sense that it is an emergency situation. In my previous talk, I was actually arguing that it could be compliant with rule of law, but it could, in some cases, it's not compliant with rule of law, as what, for example, current regulations in the Philippines have done. It is compliant when it is actually part of deliberation, when the regulations or the laws actually were deliberated upon, and to actually address proportionately and appropriately the issues called for. For example, restrictions on movements can be justified because the pandemic or the virus could actually, could spread. But it is not compliant with the rule of law if actually the police or the military goes around and just arbitrarily taking people and putting them on jail without even giving them the benefit of doubt, without even giving them due process. So for example, in the Philippines, because we have history of martial law where it was indiscriminately imposed, the current constitution now actually imposed controls on the exercise of martial law. So even if there is martial law, it doesn't mean that authorities could actually disregard human rights. So in the sense that in the pandemic, the imposition of emergency regulation and laws do not exempt the state and state officials from observing due process and respecting human rights of people.
Okay, thank you for the answer, Mr. Imelda. Any other question maybe from the audience? Because I have a question too also, but please, maybe this is not common for everybody to ask question, but I'm really interested to find out what has been done in Philippines. Maybe Mr. Hasanuddin, do you have any question? Oh, so the Master of Ceremony have question. One more question, please. Look to the camera.
Okay, thank you very much. So my question is, how do you consider this reality during global pandemic and when there are increased opportunities for corruption to take place, while at the same time not compromising an effective public health response? And maybe it's correlated about the transparency and the governance for the society, or especially for Indonesia. Thank you. Maybe you have an idea about this. Thank you.
I think I did not really hear your question, so maybe can I ask the moderator to repeat the question?
Okay, I'll do some question. Maybe the question is about how the government have to deal with corruption in the pandemic era, since there is so many action that maybe will disregard the law when it's coming to budget controlling. Maybe, for example, in Philippines, how the government taking care of the pandemic with the issue of corruption in hand.
Mm-hmm. Oh, thank you. That is a very, very good question. And my answer to it is that corruption has been like a perennial problem. And when Duterte actually came to power, the first thing he did was to actually compromise the independence of these accountability mechanisms. So as I mentioned, he stopped he discredited a very, very good ombudswoman, and then he stopped the ombudsman with people who actually don't really care about corruption, but just turn their blind eye to corruption. So all the more that the issue of corruption has actually have worsened during the pandemic. And so the pandemic has not just worsened. It's not the cause of corruption, but it actually highlights and amplifies the weaknesses of accountability institutions that would check on corruption. So if before the pandemic you have a very weak corruption institutions, then all the more that it won't actually survive or would not actually function during the pandemic when it's hard for people to actually complain, much less for the bureaucracy to function. So in fact, in the Philippines, corruption has become rampant, even worse during this pandemic because the corruption institutions have not worked even before that, but also have been undermined. But at the same time as well, that during the pandemic, it is hard to actually to investigate corruption practices. So insofar as in Australia is concerned, so we have here a very, very strong institution. And so with strong institution, regardless of emergency or pandemic, the institutions will work. Thank goodness, we have not actually, I have not heard of any corruption related to the pandemic here in Australia, which shows that with good institutions, then corruption can be abated. But leadership that does not actually provide a high regard for independent accountability institutions, then this is a huge problem. And so in my presentation, the issue is, if these democratic institutions actually do not work, what can we do? Where do we seek the rule of law? And I think we just go beyond, institutions and laws, but also looking at, different places. Civil society, for example, I know it's been hard to function during the pandemic because of emergency, but these are institutions that are actually advocating for and fighting corruption. The media, I think, I don't know what happened to what is the state of the media, of independent media in Indonesia. But in the case of the Philippines, the government even padlocked one of the biggest media network in the Philippines, the ABS-CBN, depriving many people of important news, but also depriving people, many people, especially those in the periphery, in the rural areas, to actually hear information about what's happening about the pandemic. But also it also narrowed down the space for people to actually take up the complaints on corruption against the government.
Okay, thank you for the great answer. Maybe we have a third question, maybe. So you have understood the answer.
Hello.
The next question will be Mr. Hasanuddin. Okay, please.
Yeah. Thank you, moderator. And thank you, Professor Imelda Deinla, from the amazing presentation. I have two questions about your presentation. The first one, what is your view regarding democracy in Southeast Asian countries? Are there similarities in values or values of democracy, or are there differences between each country? And the second one, how is the development of the rule of law implemented by countries today in your view? That's it. Are you clear about my question?
Yes. Yeah. Thank you very much, Kadaruddin. Thank you for really, really great questions. These are difficult questions as well. As we know, in Southeast Asia, countries have very different systems. We range from very democratic to authoritarian to in between. And we know that among the countries in Southeast Asia, somehow it is, thank goodness, they say, according to certain measurements, it is Indonesia that's actually quite still high up there in terms of the democracy kind of level. Unfortunately, in the past 15 years or so, democracy has been showing a lot of regression, so they say. I actually wrote a background article on democracy in Southeast Asia, and I was looking at the trends. before I was hesitant to conclude that, regress in democracy is really deteriorating quite quickly. I was very hesitant because most of the countries in Southeast Asia, at least the democratizing ones, Indonesia, Philippines, and Thailand, Malaysia, there is fluctuation, but we still maintain that, that the value of democracy as a way to govern, as a way of life for many of these for these countries. So before I would say that, we credit it to the, to the process of democratization. So democratization is not a linear process. It has its ups and downs, but I think the Indonesia, for example, and the Philippines before Duterte had exhibited that resilience, and it actually maintained democracy and even improved on a lot of indicators. For example, rule of law in the Philippines has improved a lot prior to Duterte administration. In Vietnam, I was looking at the indicators in Vietnam. They are actually improving on certain indicators on rule of law and things like that. But the democratizing countries, the Philippines and Thailand, they are really showing fast regression. And I am afraid, I'm very concerned that the regression might be too bad, too bad that we are unable to actually unwind it back, or if we wind it back, that we have actually ruined much of our institutions, and that is happening now. Our independent institutions, our Supreme Court, they are actually quite compromised. So unfortunately, we have very weak institutions. In many ways, I think Indonesia is still holding on, and there is some hope actually in Thailand. So in Thailand, the hope is not in constitution, in the laws, because the laws and institutions have been used to actually impose an unrestrained monarchy and and military. So it is why people take up to the streets, young people, to reverse the process. And that happened also in the Philippines during the time of the Marcos years, that people have to resort to people power. And I think it also happened in some degree in Indonesia. So unless the people themselves are actually are not vigilant, are vigilant, this sort of regression, democratic backsliding, can actually be arrested. I have faith actually in the civil society in the Philippines and in Thailand, and we also have to mention Malaysia, which seem to be also one of the most difficult cases. But look at it, on the bright side, they are able to actually hold a really fair and free elections, and at the same time actually reinstall a leadership that is actually a bit more responsive to the people of Malaysia. So I think right now, I think in the Philippines, there is also some sense that people are fatigued or are tired of going to the streets and, petitioning the government. I think the same as well in Indonesia. But I think that we have a lot of learnings, and I think we have a lot of experiences, and I think experiences from old would also be a way to learn from them. But also, as I mentioned, really looking at these informal networks. There is a good work by my colleague here at ANU, Dr. Bjorn Dressel, on informal networks, at least in the context of judiciary, that really looks at the relationship, how relationships are formed, how we can use these relationships to lobby, to advocate. And of course, the use of other mechanisms. So for example, in our bureaucracy, really strengthening the bureaucracies is really, really very important, because as we know, the backsliding in the Philippines was brought about by that sense of the people that the government is not delivering the services that they need. and that there is huge inequality among the people. But if we actually work on, how to make the judiciary, the bureaucracy work, I think it is one of the things that we should be really looking at, professionalizing them, inculcating rule of law in the bureaucracy is very important, because I think what is missing at this time is we divorce rule of law from other aspects of politics and society. We only think of rule of law as mainly the courts, but rule of law actually would not be able to work without the people, without the institutions who support it.
I think that is a very wise answer from Ms. Imelda and Deinla. So maybe is there any other question? Because for the last question will be from me. Excuse me, Ms. Imelda. I have a question we know what this pandemic has been brought to every country in the world, but I just want to ask about whether in Philippines or I have the same issue in Indonesia. So in Indonesia, there is a assimilation program that since the prison cells are already overpopulated, so when the pandemic started at January throughout the world, on March, our government decided that we have to release some of the inmates in prison cell so they can be released back to public and to prevent the virus erupting in the prison cell. So I want to ask a question about how maybe if that is the same happening to or maybe you have the government there have a different approach on this pandemic regarding to the people in the prison cells. Thank you.
Thank you for that very excellent question. In fact, I got invited for a talk specifically on that issue, and my argument was during the pandemic we should make actually our law more compassionate. We should make our regulations more compassionate in order to address many of these issues that ordinary laws have not actually foreseen. So laws and regulations did not foresee the pandemic. So our laws should actually be made to be more compassionate. And I think compared with the Philippines, Indonesia actually released its prisoners. So there are categories of prisoners that were released in the Philippines because we have a very populist leadership. So institutions actually don't think, they don't respond without the directive from above. But this is a pandemic, so institutions should actually work without being directed at. But this is not what happened in the Philippines. They waited a while, so the courts waited a while, to the extent that actually the pandemic is spread in many of the prisons in the Philippines. So one of the biggest cities, Cebu City, actually had a bad wave of the pandemic because of the prisons not being able to be released on time. So they created actually it was a petri dish. They compared it to the petri dish because the prisoners have nowhere else to go. But also considering that, like Indonesia, the Philippines actually has one of the most congested prison in the world. And so with that congestion, actually, it's not just the prisoners actually getting sick, but actually the staff, the personnel getting sick. So those personnel in the prisons infected their families and so on and so forth. So it led to actually a massive explosion of infection that could have been prevented by quick action, by compassionate thinking among our judges and the justice system. And there are categories actually of prisoners that whose guilt are not determined beyond reasonable doubt. I don't know if it is the same in in Indonesia, but in the Philippines, more than half of the prisoners are on remand, meaning that they are still on trial and that their guilt has not yet been determined. So many of them are actually could be innocent. And so giving that reprieve could have actually helped. Not only is the pandemic, but to give justice to those that are unjustly imprisoned.
Well, thank you for the very great answer. We have to applaud for this Dwia for the very.
Thank you very much.
Questions. So we have to move on to the next paper. It will be paper from Professor Hasanuddin, but unfortunately, since she was unable to be presented the paper herself, so maybe Habib Committee will work on this. Maybe Mr. Maskun will read the presentation, and the question will be. Oh yeah, so Mr. Maskun also will try to answer the question and answer. So please welcome the next speaker will be presented by Mr. Dr. Maskun SLM. The time is yours. Thank you.
Okay, thank you so much for moderator for this opportunity. And also I would like to apologize for this situation actually, but it's really probably she couldn't avoid the situation in Selangor right now, and so that's why she asking me to get involved for her presentation, and then why I'm surprised actually to sit in front of all of you and then also giving the Prof because this is part of our research actually, even though this is comes from the Malaysian perspective actually, but actually I would like to just to emphasize some of the same idea regarding to the plastic pandemic, both in Malaysia and in Indonesia, especially in terms of the regulatory framework, both of them. Next. Yeah, the title of this presentation would be Plastic Pandemic in Malaysia, Unlocking Solution for Sustainable Empowerment. And then I would like also to add with some Indonesian, especially in the area of regulatory framework. As we know, when we talk about the plastic pollution, actually, this has become the hot issue actually not only in Malaysia and Indonesia, but all around the world. Because when we see the situation, we will see that talking about the plastic pollution in all countries, in all provinces, including Indonesia, of course. You will see from this background on the slide, you will see how the practices in France and in other countries, how all the flora and the fauna will be in dangerous situation, and what should we do when we see all these things. And then this is take place not only not only in the area of the regional issues sector when we talk about the plastic, but we talk about the all important issues actually regarding to the plastic. So when we see in this situation, actually, next please, you will see how plastics in terms of becoming the pollution actually, and they throw away in the ocean, for example, it would be bring some impact on human health. In somehow we didn't realize actually when we eat feces and other feces, for example, and then we don't realize that those species, for example, is already impacted by the plastic set, and it would be dangerous for the human being health. Of course, it not directly will be bring the influence to the human being, but for long time, for in the future, it would be dangerous. So that's why some idea. So some idea. If you see in the slide, you will see how a green reality. So as how, for example, plastic impact on the human health, how the plastic can help the hidden cost of the plastic planet, environmental and human health impact on plastic pollution, and so on. So this is the reality we facing right now, and we have to be work together. We have to be consider in order to see how important this issue to be dealing with all countries, including the people who live in these countries. Next, please. Yeah, if you see the previous moderator, please. If you see the previous slide, if you see the annual global plastic production starting from 1950 to 215, you will see how million tons plastic goes to the domestic solid waste actually. So because every day we produce plastic, and then every day we do not aware that how to use another thing instead of plastic. For example, the bottle plastic, especially because we always drink something and then take it from the bottle plastic, and then most of the company also is producing the plastic bottle, for example, and then it could be dangerous because we didn't realize that this is really big. You will see from the chart, for example, coming the source from Richie, starting in 1950 to 2014, you will see starting from all tons goes to 450 tons only during around 60 years, 60 years, 60 to 60 years, 50 to 60 years, and then you will see how people use plastic, and then they don't care about after they use of the plastic, whether they would like to throw away the environment. They don't think about which is this dangerous for the environment. They don't think that just enjoy the life at the time. And then right now we have to consider value because there are so many things that we have to consider about the plastics, including especially in the area of these SDGs and then sustainable development in perspective of the environment. This is you will see in the plastic use based on the still the same from the Richie in 2018 how packaging and so on, it will be higher than the others. Then and other they saw us about the how market share of plastic in major market segment in Indonesia 2008 and 2018. I think what happened in Malaysia, I think it's quite the same as in Indonesia and in other countries in especially in the developing countries. How we use plastic as the major for packaging aspect, for example, in all daily life. And then this is we couldn't avoid it because this is not only talking about how we aware, but also how we change our mindset, how we change our mindset to try to move from plastic perspective goes for use another beside the plastic. Next, please. And then, yeah, you will see as the comparative studies, how the plastic is used. You will see from the charts. This is source coming from the UN in 2008. It started in 250. 2015 goes to 2018. You will see what happened in America, Japan, United Kingdom, Germany, Hong Kong, and Australia itself, how the trend of using plastic are increased time by time, year by year. You see, from the America, for example, you see comes from in 2015 50 tons, and then 4 years after they will almost in 250, and it's quite the same as in other countries. The trend saw us that
the use of the plastic as either for the packages or other purposes, of course, it increased, including in ASEAN majority, and you will see as the Hanim Kamarudin provide us the data example. For example, in Malaysia, import of plastic waste from top 6 countries 2015 and 2018. So this is those data as slide in front of you, ladies and gentlemen, show us how important us to be part to dealing with plastic. So we have to more and more consider not only intake of the attitude but also related to the regulation actually. Yeah, and then next slide, please. You will see from the Malaysian perspective. You will see from the Malaysian perspective before slide. Please. Okay. 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 From Malaysia perspective, I will show you this waste generation in Malaysia 212 to 118. You will see you see from 2013 goes to 2018 is quite the same as the trend of using the plastic time by time is increased. So that's why we can conclude temporarily, but that most countries, or we can say probably all countries around the world have the same trend to use plastic and produce plastic as the new problem related to the plastic pollution, for example. Next, please. Even in somehow actually because countries realize that they use the plastic, and in the same time they try to recycling those plastic. But the problem is not all plastic production can be recycled. You see. So you will see, from example, from the data coming in this Hanim slide from Germany, United Kingdom, Singapore, Thailand, and Malaysia itself, and including, for example, if I have to add some data actually in Indonesia perspective. Also, we have the same trend also to try to recycling those plastic actually. But the problem is not all plastic waste can be recycled. And in this situation, we have to think more and more to dealing with this waste plastic. And in the area of this one, this is would be bringing a new problem. And then when we find it when the question comes to the as a problem, so the basic question, what our strategies, either in the global strategies or regional strategy or domestic strategies to be implemented. In some countries, actually, for example, if you see in the slide, they say, for example, in Peru Congress, they approve ambitious national law to discourage and significantly reduce the single-use plastic, for example. In Canada, also, they use, ban single-use plastic in 2021. In America, because from the Trump has already signed the bill to clean up ocean plastic. In San Diego, in America, and so on and so on, including in Indonesia itself. So this situation actually needs our commitment. And then when we talk about our commitment, we have to concretize the commitment goes to the strategy. why we have to go to this strategy? Because strategy means would show us in the situation that we prepare something to do in dealing with the plastic problems. So that's why strategy we need, because it's impossible to dealing with the plastic problem alone, because we need cooperate with others. Let's take example why the strategy, global strategy we need. Because for example, when someone throw away the plastic on the ocean, it can be guaranteed from someone that the plastic only will stay in its territorial, in its ocean. I don't think so, because it would be, when we put it on the water, it means that the rest should be follow the water where the water goes. So that's why talking about the plastic waste in the area, in global area actually. Also, we need the global strategy. We have to work together. We have to cooperate it one with another in order to dealing with. Without a good collaboration with among the countries, I think it's very difficult for us to dealing with this big issue about the plastic waste. Okay, and then next please. And then the question is, you will see from example, the idea of after putting the global strategy. So we goes to the idea of the pre-plastic environment. We try to to agree that to use another element of product beside the plastic in the theory actually. But in fact, in somehow it's very difficult also. Even in Indonesia, for example, right now it's very difficult. In somehow the government already banned the plastic use. For example, the plastic straw, for example, starting since last year. Also, it's very established in Indonesia. But in fact, I don't think so. Based on my experience and then based on the research that I'm conducting with the Hanim in this area, it's quite we find some difficulty to see. So that's why the question: is it successful about burning the plastic straw, for example, or the plastic bin? I don't think so. I don't think so, because this is even this is still in because we started since September 2020 of the research, and it is going on the project. But it's quite the same as the conclusion for the project. Next, please. And then this is a regulatory framework, of course. This is regulatory framework. In somehow they write it down. Hanim write it down based on the Malaysian perspective. In Malaysia, no specific law to govern reduce plastic pollution in Malaysia. Although Environmental Quality Act 1974 in Malaysia. Also for the also for the Solid Waste Public Waste Management Act 2000. How about the Indonesia? In Indonesia actually, if we talk about the regulatory framework, so the basic law, when we talk about the plastic, we will go to the law number 32 of 2009. This is on utilization and protection of environmental law. But in this law, actually, it's got the same as like Hanim say, that it doesn't specify mention about the plastic. So that is the reason why actually in 1 year before the law number 32 2009 goes to the law number 8 2008, the government tried to show how commitment it is, and then enacted the law number 8 of 2008 concerning on the waste management. And one of the content of the waste management is including plastic. Okay, that is including plastic. And then as derivative from the law number 8 of 2008, the government have already also issued the government decree number 81 2012 regarding to the municipal solid waste management. So municipal solid waste management. Those laws actually, the three laws actually as the regulatory framework from Indonesia. So how commitment Indonesia it is, how commitment Indonesia it is based on the regulatory framework. But the most important things that we have to see that commitment in the area of such thing of issue like plastic actually should be how those law can be applied in appropriate way. So how they can be applied in practice, because this is the most important things. How the law can be enforced to the society who violate those law. This is become the big question that we have to answer when we talk about the regulatory framework. Next, please. Okay, this is a zero single-use plastic 2018 and 2020. This is what Malaysian thinks and what Malaysian strategize for this to go to the zero single-use plastic. Next, please. And this is a Malaysian plastic use, plastic pollution, plastic waste imports, discarded single-use plastic, prohibition of liquid in manufacturing, encourage recycling of waste, encourage sustainable manufacturing of plastic alternatives. And then, yeah, the last thing that I have to deliver, because I do believe that we are in terms of the pandemic COVID-19 actually, we produce a lot of plastic actually. We use a lot of plastic. We produce a lot of plastic, and this is become a next problem actually. This is become next problem regarding to the plastic. For example, we use the gloves, we use the mask, the material of the gloves and the mask comes from the plastic. And this is become the next question. The next question: how we predict the increase of the number of plastic debris, of course, after the COVID-19, and we do hope that the pandemic will be ended soon, because the more this pandemic goes, it will be the most we use the plastic debris itself. The last, yeah, I think that's all my just to complete presentation from Hanim, and then giving some some add information regarding to this research. Of course, this is still doing the research, and we will see inshallah next year we will see how this project can work smoothly, and then resolve a lot of data in order to see how important discussion on plastic pollution around the world, including Indonesia and Malaysia. Thank you so much, and again I apologize for this condition, and I return to the moderator. Thank you so much.
Thank you, Mr. Maskun. Maybe as regarding of this issue of the unavailable for Professor Hanim Kamarudin to present it in this her paper. So as a collaborative research results, we have provide some quite time for question and answer. Maybe any question from the audiences we will try to keep the question and we will try to, maybe Mr. Masud will try to answer. But even if the question maybe will not be answered completely, we have consulted that maybe from some of the questions will be sent to Professor Hani herself. She will try to answer the questions by email. If that will be taking a long time, maybe not today, but the committee has promised that maybe the answer will be provided in the next few days. So maybe from the audiences whether we have a question or not.
May I ask question?
Yes. Name, please.
Yeah. So is it me? Okay. So good afternoon. My name is Mylinda. I'm from Faculty of Law, Universitas Gadjah Mada. So thank you very much for the moderator for the opportunities. Actually, regarding the plastic waste, it's becoming getting attention from all over the world, government of all over the world. So you have already saw us the several challenges you face, particularly in Malaysia, to in doing the reduction toward plastic pollutions. And then my question is, what do you think is the most effective way to particularly increasing the what is it? Because the also important part to make it successful is the participation of the people. So what do you think the best solutions to make people understand and will voluntarily participate in lessons the using of plastic, so it will reduce plastic pollution? Because in my experience in Indonesia, it's not that easy to make people understand, even though there is incentive given or even sanction given. Yeah, because it's easier to use plastic everywhere. So maybe you have the suggestion to that. Thank you, moderator. Thank you.
Thank you for the question. Just one question maybe for Mr. Masud Bansar, please.
Yeah, thank you so much, Ibu Melinda. Yeah, I think this is hard question. Okay? This is difficult question coming because when we talk about the effective ways, especially in Indonesia, for example, this is very difficult. I do realize this fact. Even in some provinces, they provide solid banking, and then the government or some NGO will pay people who who collect the plastic waste, and they pay. But and fact also there are some policies coming from the government also. But when we saw the fact surrounding us, it's quite difficult. I agree with you, I believe that this is better. But I think the most important things that we do have approaches, and then the most important things in my mind is how to change our mind, to change our mindset actually. So the way we think about how to use the plastic should be in different ways. Why I say this my hypothesis, because even actually we say that those plastics can be recycled, for example. But the most important things, in fact, in Indonesia, we do not prepare something or some facilities to support this idea. So in this situation like this one, it is very difficult positions. But the most important things, first, how to change the mindset of the society, of the people.
how to socialize, the law number 8, 2008 regarding to the solid management. Even in Italy, it's almost more than 10 years, but the consequence of that, the impact of that, it is still the same as in all over in Indonesia. Let's take an example in summer when in Bali and in some tourism places in Indonesia when in the beach, for example, in some time, we find all the plastic waste coming from the ocean goes to the and any situation it would be but the most important thing beside the change the mindset, the society mindset, the individual mindset, we have to also enforce the law. We have to enforce the law consistently. This is become the problem in Indonesia also when we talk about Indonesia itself, because when we talk about the enforcing the law, it's quite difficult for us. There are some, there are some situation that we had to say and then dealing with the situation also. So it's credible. But the most important things, according in my mind and then my little bit experience regarding to the plastic that change the mindset is one way of the good way. Beside providing the facilities and then also the create the a good regulatory in the framework in the great framework in Indonesia. And I think it's what the same as you all the countries as the slide has been solved all of it. Thank you so much.
Thank you, Mr. Masker, for the answer. Ms. Melinda, I hope that will be fulfilling your questions. I couldn't agree more that we have to educate our people, or maybe our children more about how dangerous this plastic waste is, because maybe the older generation, or excuse me, have already been polluted already with plastic. We can maybe we hope that our children in the future will have the bigger awareness of how dangerous this plastic waste to the environment whatsoever. So maybe that will wrap all of our session for the second preliminary. We hope that you enjoying our presentation. Maybe we can have a better opportunity the next time we will have this conference later on, maybe sometime next year. We hope. And we, from the committee, we do apologize for the absence of Professor Hasanuddin because this is a very unfortunate event because she has a activity in very exactly same time with us, so she is not available. So maybe as the closing statement, I will say thank you for all the presenters, for the committee, and thank you. Maybe we'll see you next time. We will move on to the next session. I will give back this moment for the Master of Ceremony. Thank you. Assalamualaikum warahmatullahi wabarakatuh and good day.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you.
Thank you for Mr. Suman Hakim SIMA as the moderator and also for Mr. Maskun and for Mrs. Imelda Deinla. Your Excellencies, ladies and gentlemen, these are the agenda, and we will continue for the fourth session after lunch break, and it will take around 40 minutes. And we will now, please be note that our session will start at 1 o'clock, and also we want to inform you that our fourth session will be. Our speaker for session is Professor Dr. Topo Santoso with Professor Dr. Eddy Hiariej, and who will do it by our moderator, Mrs. Arminta Pratiwi Arifin, SHLM. Ladies and gentlemen, Your Excellency, now we come back to the plenary session. For the fourth session, our first speaker is Professor Dr. Topo Santoso, M.Hum, from University of Indonesia. And the second speaker will be from Professor Dr. Hiariej, M.Hum, from Gadjah Mada University. and will be led by our moderator, Mrs. Arnita Pratiwi Arifin, SHLLM, as known as the lecturers from Faculty of Law, Hasanuddin University. For Mrs. Arnita Pratiwi Arifin, SHLLM, please, the floor is yours.
Thank you very much for the MC. Ladies and gentlemen, honorable speakers, colleagues and friends, welcome back to the plenary session of the Second International Conference on Trade, Business, Human Rights, and Globalization, Faculty of Law, Hasanuddin University, 2020. My name is Arnita Pratiwi Arifin. I'm supporting lecturer of Law Faculty of Hasanuddin University, and I will be your guide through this plenary session. I'm so delighted to welcome you all, that all of you all here eager to engage with the current legal issue during the pandemic, and you are how we managed to find its solution. It goes without saying that the global pandemic of the COVID-19 has affected all sectors of the country, including the legal sectors. It has emerged as a hot topic, both local and international. The rapid growth of the criminal cases during the COVID-19 outbreak has raised many questions on how we are going to make the legal protection, legal enforcement, and legal proceedings more effectively in this pandemic era. This is, of course, should be taken into account by the government, but also by us as scholars and academics. And in this exact occasion, I am pleased to welcome our honorable speakers who are the criminal law experts of Indonesia, who will then discuss and share his expert opinions regarding this matter. Please allow me to briefly introduce our speaker for today. Our first speaker is a special guest from University of Indonesia, Professor Dr. Topo Santoso, M.Hum. Professor Topo was born in Wuryanto, Central Java on July 5, 1970, completed his undergraduate degree at the University of Indonesia in 1992, Master of Law also at the University of Indonesia in 2000, gained his Ph.D. degree at 2009 at the University of Malaya, Kuala Lumpur, Malaysia. He has been a senior lecturer of the Faculty of Law, University of Indonesia since 1994. He is currently also an outstanding lecturer at the doctoral program in law at the University of Jambi, University of North Sumatra in Medan, as well as an extraordinary lecturer for the University of Riau and Batam International University. He teaches several subjects including criminal law, application of criminal principles, general election, regional law, and comparative law, and others. Professor Topo has also served as the Dean of Law Faculty, University of Indonesia in 2013 to 2017. He also worked as an advisor at the Partnership for Governance Reform in Indonesia. He has also been a member of the International Academy of Comparative Law based in Paris, France since 2016 until now. In 2015 to 2018, he became the chairman of the Indonesian Comparative Law Lecturer Association. Today, he has written 25 books and various international journal articles. He has also written hundreds of opinions articles in the national mass media and has been active as a resource person in various seminars, workshops, and other scientific activities, both local and international. Before I invite Professor Topo, I would like to remind each speakers will be given 20 minutes to present his paper, and after that there will be 30-minute session for the Q&A session for all the participants who wish to ask a question for the speakers. Okay, without further ado, I would like to invite Professor Topo to present his paper titled Prevention of Misuse of COVID-19 Mitigation Funds in Indonesia. Professor Topo, the time is yours.
Thank you, moderator. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. It is my great pleasure to be invited as a speaker in this very important conference. And thank you for the Rector, thank you for the Dean, Professor Farida, my good friend, and also um, congratulations for the commencement of this conference. And I should also mention my friend, Professor Eddy Hiariej from UGM, and also all presenters and all participants of this conference. I would like to presenting my paper which entitled Prevention of Misuse of COVID-19 Mitigation Funds in Indonesia. I will start with the question. I should mention that control the pandemic is also, we need to control the misuse of mitigation funds, which is very important to control the pandemic. And this is the statement of President Joko Widodo in September 1st. The president mentioned that compared to other countries, Indonesia remains under control. It needs to be maintained. COVID-19 mitigation is still at a point where it is under control. So the question is, how about the funds? How about the mitigation funds? Is it under control or not? So this is the main issue of my presentation. This is the structure of my presentation. It's comprised 5 sections. Start with introduction, and followed by legal framework related to COVID-19 in Indonesia. And then I will discuss about the legal framework related to misuse, or it could be mentioned as the corruption of COVID-19 mitigation funds, and how to prevent. And lastly, I will conclude my presentation. So mitigation fund and corruption. COVID-19 outbreaks, is it means also corruption outbreaks? This is, we can find this kind of words in many articles nowadays, in many newspapers and also articles in the journal. So the world is now impacted by the novel coronavirus disease of COVID-19. The World Health Organization declared COVID-19 as a global pandemic on March 11, 2020. In Indonesia, only on March 2nd, 2020, the Indonesian government, Joko Widodo, reported the first confirmed 2 cases of COVID-19 infection in Indonesia. And those 2 cases is happened in my city, in Depok. Indonesia is the 4th most populous country in the world, and thus is predicted to suffer greatly and over a longer time period when compared to other less populous countries. For example, in ASEAN countries, Indonesia nowadays has the biggest number of positive COVID-19 cases. It is predicted that the poverty rate, this is the impact of the COVID pandemic. It is predicted that the poverty rate will increase from 9.2% in September last year to 9.7% by the end of this year. This implies that 1.3 million more people will be pushed into poverty. Under the most severe projection, the poverty rate will increase to 12.4%, implying 8.5 million more people will become poor. So this condition, of course, need to be handled, needs to be faced with a big fund, big amount of money in terms of social safety net and others. So this is the trend of the active COVID-19 cases in Indonesia. And even though a couple of last weeks, we see the downgrade of the rate, but we see that the positive cases in Indonesia still the biggest in ASEAN countries. So we now move to the other background of this paper related to social safety net. We call it in Indonesia as bansos and other term related to social safety net. The scale of the impact is unprecedented, and studies have suggested that it might take more than a decade for the world to recover socially and economically. Under the most severe projection, as I mentioned, the poverty rate will increase to 12.4%. The implication of this is that Indonesia needs to put in place social protection programs to assist the new poor in addition to the existing poor. Dear presenters and also participants of the conference, in my observation, there are several writings related to the COVID-19 pandemic. There have been various writings discussing the COVID-19 outbreaks in several international journals. In general, these articles discuss the handling of COVID-19 in terms of health and economy, as well as how the regulation or policies of various countries in dealing with the COVID-19 outbreak. In Indonesian context, since the beginning of the pandemic, there has been an analysis of COVID-19, for example, by Jalanti and et al., who analyzed the responses of the government, non-government organizations, and also the weaknesses in this response. The other writings, like from Ronald Raja and Greenfield, entitled Keeping Indonesia Economy Afloat Through the Pandemic. So Indonesia faces one of the most difficult outlooks. This is from the economic analysis regarding the COVID-19. And the other writings related to fiscal policy, to also related to COVID-19 pandemic. The other writings about discretion. This is from legal perspective. Firdaus and Erliana discussed the use and supervision of discretion issued by the government for handling the COVID-19 pandemic. The other writings is also from legal perspective, from Mahardika, discuss the potential for irregularities in Perpu number 1 of 2020. Also, the other topic related to COVID-19 is about the death punishment for corruption. This kind of sanctions provided in the anti-corruption law. And also the other writings about security implication of COVID-19. I find there is a very rare discussion, the article who discuss about the misuse or the corruption aspect of the COVID-19. So my presentation, the purpose of my presentation would be to analyze the Indonesian legal framework related to the prevention of the misuse, could say corruption of mitigation fund. So the second part of my presentation related to the legal framework of COVID-19 in Indonesia. Nowadays, most countries are caught unprepared to the speed and scale of impact from the COVID-19. Several national regulations have been produced by the government at different levels, from the presidents to ministerial levels during January to March 2020. In Indonesia, there are several rules and regulation, law and regulation have been produced to guide national and local response. Most of the regulation were issued after 13 March, when the President Jokowi established a task force. I could mention, among others, of the framework of the law and regulation. First, of course, we need to mention law number 24 of 2007 concerning disaster management. The subsidiary legislation, including government regulation, in lieu of law number 1 or Perpu number 1 2020 on national budgeting policy and stability of budgeting system. The other would be I should mention Presidential Decree or Kepres 9 2020 and decision of Minister of Health number 1.7 and the other regulation from Minister of Finance regulation on distribution and the use of shared incomes, gain, fiscal allocation. Now the question would be, do we have legal framework related to misuse of COVID-19 mitigation funds? So Perpu number 1 of 2020 provides enormous powers for a number of officials to take preventive measures that do not correlate directly with the COVID-19 pandemic problem. one of which is liquidity assistance to banks that are both systematically and non-systematically affected. So some authors, some writers mentions about the potential for legal irregularities in government regulation in the Perpu. Number one, officials are given the right to immunity not to be prosecuted, both criminal and civil. This is one of the provisions in that Perpu. So we may say that there are two kinds of irregularities or two kinds of misuse of the funds or related COVID-19. First is of course, the big amount of money related to the procurement aspect of the COVID-19. And the second is the misuse in fund related to distribution of social safety net. So those two kind of misuse or irregularities or corruptions can be mentioned when we discuss about the COVID-19 in Indonesia related to corruption. But this paper, I should mention that this is focusing only on the kind of problem related to distribution of assistance fund or bantuan sosial in Indonesian term. So there are several cases already reported by the police, some already brought to the Attorney General, the Jaksa, the prosecutors, and some already decided in the court. This, for example, we can mention some of the news in July. There are 3 regions in West Java are suspected of misappropriating social assistance funds or bansos for community economic recovery due to COVID-19 pandemic. This was done by cutting off or embezzling bansos funds. In August 2020, the National Police Headquarters handled 102 cases of misappropriation or misuse of COVID-19 social assistance funds. Of course, nowadays in November, the cases must be higher than that. The abuse was carried out by mayor, head of social services, sub-district heads or camat, village heads, kepala desa, supplier of goods, and others. This happened in 20 regional police conducted in, I could say it in more than 20 provinces by cutting social assistance funds, the bansos, unequal distribution, reducing the balance of basic necessities, not being transparent, and others, modus operandi. So when we discuss about how to handle that kind of misappropriation or misuse of mitigation funds of COVID-19, we could mention this concept we use in criminal law. It's called criminal policy, toward use of mitigation funds. Criminal policy can be divided into 2 kind of concept. First is penal policy, then the second is non-penal policy. Within the concept of penal policy, we could mention the criminalizations, and this provided in the UNCAC, United Nations Conventions Against Corruption. There are several conduct that should be criminalized, and the perpetrator should be punished. And we also should mention in this term of penal policy, the law on anti-corruption. In Indonesia, law number 21st of year 1919, and also law number 20 of 2021, yeah, 2001. And also in terms of the institutions and also the court, we can mention there are several institutions like police, Attorney General Office or Prosecutor's Office, Anti-Corruption and Commission Office, KPK, and also corruption. With regard to the second concept, non-penal policy, is mostly we discuss about prevention, which is the main issue of my paper, is prevention. This also provided in UNCAC. there are several provisions in UNCAC focusing on the preventions. Prevention by means of improving procurement systems like e-procurement system and others. And also to improve monitoring, education, improve NGO rules and others. Dear participants and also presenters of this conference, this is the legal framework how to handle the corruption cases or irregularities related to fund to handle COVID-19. We can use law number 31 of 1999 and law number 20 2001 on corruption education or Undang-Undang Tipikor in Indonesian terms, and the second law number 23 of 2014 on regional government. So legal basis for processing irregularities. This is, in summary, we can describe as follow. The procedure for handling suspected irregularities in social assistance funds or bansos refers to Article 385 of Law number 23 of 2014 on regional government. Article 385 paragraph 1 of the law mentioned that the public can report allegations or dugaan of irregularities by the state civil apparatus or ASN in the region to the government internal supervisory apparatus or APIP in bahasa, aparatur pengawas internal pemerintahan, and or law enforcement officials. APIP conducts an examination of the complaint. Besides that, law enforcement officials examine complaint in coordination with APIP or other non-ministerial institution in the field of supervision. In Article 3, in the same article, paragraph 4, if it found that evidence of an administrative violation is found, so the handling will be submitted to APIP. If there is a criminal violation, it is handled by law enforcement, by police, prosecutors, or KPK. Cases with small nominal loss are submitted to APIP. If there is a criminal act of corruption or corruption offenses, the law on anti-corruption will be used in that kind of cases. So that is, in summary, how the law enforcement in many areas process the violation of the COVID-19 funds. So we come to the last part of my presentation, how to prevent. We can learning from outside, from UNODC, for example, United Nations on drugs and crime. We can also learn from USAID program, and also we can learn from UFO anti-corruption resource centers. I will mention the summary of the approach used by those institutions. How to anticipate corruption of COVID-19 mitigation funds. According to UNODC, there are good practices in ensuring compliance with Article 9 of UNCAC. This related to the establishment of a sound procurement system, transparency in procurement, objective decision-making in procurement, domestic review or bid challenge system, integrity of public officials, and soundness of public records and finance. So this mostly about the procurement system. I already mentioned in my beginning of my presentation that procurement is one of the area which corruption can happen in this regard. So UNODC also has guidebook on anti-corruption in the public procurement and also the management of public finances. Public procurement as a major risk area of corruption. But also UNODC, which mentioned UNCAC, there are several concepts like prevention, criminalization, and law enforcement, and also international cooperation and asset recovery. In terms of accountability and the prevention of corruption in the context of COVID-19 pandemic, it is important to be mindful that the purpose of the recent economic responses made by member states of UNCAC, of course, are not intended to provoke economic stimulus activity, as would happen in times of cyclical recession, but rather to prevent economic catastrophe and provide financial, medical, and social support to the poor, the elderly, women and youth, people with disabilities, the employment, small, medium enterprise, and those lacking access to social and public services.
Unfortunately, your time for presentation is up. Please conclude your presentation.
Sorry, how long?
One more minute.
Okay. I will come to my end of presentation. So this is the recommendation by UNODC, clear, objective, and transparent criteria for the qualification, account for the risk and vulnerability of disbursement, and others. And also the use of technology for efficient, transparent, and accountable disbursement of resources. The other approach would be from USAID, among others, in strengthening public administration, procurement, financial management system, increasing transparency and accountability, enhancing government ability to detect and prevent the misuse and diversion of COVID-19 funds, improving government capacity to audit and report on use of COVID funds and others. So I would come to my very last part of presentation, is conclusion. The mitigation funds for COVID-19 outbreak in Indonesia has criminogenic implication in terms of corruption. To handle such problem, there is criminal policy which comprise of penal policy and non-penal policy. Indonesia has several law and regulation to handle the COVID-19 pandemic, which mostly related to economic and social aspect of the crisis. With regard to the misuse of mitigation funds for corruptions, the most important law is law on anti-corruption. And the last one, we need to improve non-penal policy prevention, and we can learn from recommendations provided by international institutions. By that, I will conclude my presentation. Thank you very much for your thank you very much for the moderator. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much for Professor Topo. We will get back to you later. Okay, for our next speaker is a person widely known as the youngest professor from Gadjah Mada University, Professor Edward Omar Sharif Hiariej, or Professor Eddy. He was appointed as Professor of Criminal Law in 2010, that teaches courses in criminal law, criminal procedures, international criminal law, and others. And today, Professor Eddy will present his paper titled Processing Criminal Cases in the Midst of COVID-19 Pandemic. For that, I would like to invite him now. And Professor Eddy, this is yours.
Okay, thank you very much, moderator. Distinguished Dean of the Faculty of Law, Professor Farida Patitigi, my colleague, Professor Topo Santoso. I think I deliver my presentation maybe less than 10 minutes about processing criminal case in the midst of COVID-19 pandemic. Sorry. Extraordinary circumstances. First, we must acknowledge that the COVID-19 pandemic places all of us in a state of health emergency. The second, under criminal law, we recognize old maxim, necessitas non habet legem, means necessity no law. These legal maxims depicts a contradiction between two legal obligation or two legal interests, or between a legal obligation and legal interest. According to three theorized by Fletcher, the applicable theory in the context of the theory of leisure field, which champions preference for the least field. The next, modification for criminal procedure. Substantially speaking, criminal cases that emerge in times of a pandemic does not create a significant implication against legal enforcement. Rather, crimes committed during the times will aggravate punishment. Second, in the context of criminal procedure, modifications are necessary, such as examination through online platform. Similarly, examination in investigation states may be conducted online. So, online examination for anticipate the situation, regulate under Supreme Court regulation refers to we call Peraturan Mahkamah Agung, regulated by Supreme Court number 4 of 2020. Court examination are carried out pursuant to a strict health protocols imposed upon the judges, prosecutor, and defense counsel. The defendants would remain within detainment and given access viewing to this trial through online platform. Both I and expert witnesses may testify through online platform while still complying to standard procedure, including oath taking. The legality of online examination. Long before the enactment of ITA law number 11 2008 and the pandemic, online examination had been conducted before in Danayana Terabulo corruption case involving Akbar Tanjung. He is the former parliamentary chairman, has a defendant back in 2003. During such proceeding, the former president B.J. Habibie could not attend in person as he had to accompany his wife in her recovery stage post-surgery. Alternatively, seeing the significance of his role as a key witness, he testified virtually from Dresden, Germany. The second case, online examination, had also been conducted in the case of Abu Bakar Bashir in 2005, which took place in South Jakarta District Court, where one of the witnesses, a former terrorist, was here virtually from Malaysia. So the next, testimony made by witness and expert shall be deemed a lawful means of evidence provided that they were delivered the court under oath. For why must this testimonies delivered before the court? So that it will allow the judges, prosecutor, and defense counsel to conduct verification and cross-examination against the testimonies in the pursuit of finding the material true. Online examination would still allow the judges, prosecutor, and defense counsel to cross-examination the witnesses or expert. As such, the essence of hearing the testimony in court is not impaired, it is conducted virtually. The last, currently pursuant to health protocol, testimonies of witnesses or expert in investigation states also relies on virtual platform, especially for the documentation phase. Thank you very much for pay for attention.
For Professor Eddy. Before we jump into the Q&A session, I would like to ask permission to Professor Topo to let the audience to ask questions for Professor Eddy in advance, because Professor Eddy has a limited time. Would that be okay, Professor?
Okay, plus, yeah, sure.
For the fellow audience, is there any questions for Professor Eddy? You can directly unmute your microphone. Is there any questions? Okay, there's a question for Mr. Maskun. Please, Mr. Maskun.
You can ask in Bahasa or in English, no problem.
Okay. Thank you so much. Thank you so much, Prof. and Prof. for providing your time in this conference. But I would like to ask Prof. Eddy, actually, the question could be people something that I really need your opinion for the case of Hiariej in Bali, when Hiariej complained to the way you nation in his case actually. What do you think about it? Because it's what I mean is quite a little bit, bringing some pro and cons related to the online examination. Even though we are really realize that, as you mentioned, that it has been regulated by the Supreme Court Regulation Number 4/2020. Thank you.
Yeah, I think the special for Hiariej case in Bali, he complained regarding system of network from cyberspace. Yeah, it's not clear, but I think regarding two regulated by Supreme Court, how to examination by virtual or by online, I think Hiariej sebentar. Halo.
Yes, sir. You may continue. Professor? Professor?
Halo.
Yes. Professor Eddy, you still able to continue?
Yeah. Okay. I think it's not a problem regarding legally or legal aspect regarding proof and examination.
We couldn't hear you from Tade. We couldn't hear you.
Yep. Okay. Thank you.
Professor, your mic is unmuted.
Okay. The next question, moderator.
Is there any questions?
I ask question to Professor Topo.
At the moment, we would like to let the audience to ask questions for Eddy first. Okay. We are going to get back to you soon, okay? Is there any other questions for Professor Eddy? If there isn't any question, can I ask questions personally to Professor Eddy? Sir? Professor?
Yep.
I would like to ask
Okay.
question. Okay. During the online trial, there were several controversies like the lack of fulfillment of the rights of the parties. Trial process is hampered due to technical problems, and there are also many parties who have not been able to use information technology, and also the availability of the internet networks in certain areas when they want to conduct trials, it's sometimes inadequate. Taking into account the lack of infrastructure, will it be a potential to reduce the validity of the evidentiary process, which then will interfere the principle of fair trial? What do you think about that?
I think it's not negative impact regarding virtual examination, because in criminal case, we recognize vrije bewijs. Vrije bewijs, it means depend on judge's conviction, so that as long as virtual examination is legal, is no problem to proof and etc. But I think maybe for the examination, a virtual examination has obstacle regarding computer of network and internet of network. But for the valid evidence, I think is no problem. Depend on judges' conviction, and I think is according to fair trial. Okay.
Okay, thank you very much, sir. Is there any other question? The last question for Professor Eddy? Yes, Dina?
Yes, thank you very much, Professor Eddy.
Yep.
Yeah, I think this is a very interesting presentation and topic that you bring out, but I think people here are mostly from participants, so that they are busy to prepare themselves to present, which will hold in a few minutes. But this is a very, very interesting, and I'm really interested in this topic, as well as I think everybody. This is very important. I think myself, in my opinion, that in the trial, it is very different with offline trial. I mean the direct trial, meeting face to face from the judges, the defendant, the prosecutor, and with online trial, because for example, even if in the seminar, it is very different when we meet directly and when we meet not directly. So the effectivity of, for example, the prosecutor or the defendant to present their proof, or their especially with their proof, they're trying to prove something. It's very different. I think it's not effective, and I would like to ask you, which do you think the most ineffective part of the trial, which bring loss for the defendant to try to defend themselves, and also for the prosecutor to prove their claim? Thank you very much.
Okay, I think come back to our situation now is the dilemma between two circumstances. The other one, we have two finally criminal cases in front of the court regarding detention, etc., etc. But the other side, in a pandemic situation, I think is the alternative to finally criminal cases in front of the court, only by virtual examination. We don't have any way to finally criminal case in front of the court in a pandemic situation like now. So that I agree with you. Physically, not my virtual examination, and secara langsung itu direct in front of the court by prosecutor or by counsel of defendants and accused as the soul. Soul is a very different between direct court and a virtual court. Okay.
Do you think it will bring an injustice?
No. I think no. It's not injustice, but I state in criminal case depend on judge's conviction, not depend on virtual examination or direct examination. How to prove the case by prosecutor to convict the judges, and so as defendant constituent to prove if his client or her client is not guilty. It is not depend on virtual examination or direct examination. In criminal case, depend on proof, depend on evidence, how to convict the judges. Okay.
Thank you very much.
Okay, thank you for Mrs. Deinla for the questions. Okay, thank you very much for Mr. Eddy. Eddy for answering all the questions. And now next we are going to ask the participant to ask questions for Professor Topo. Student questions.
Thank you very much, moderator. Thank you also for the presenter, Prof. Eddy and Prof. Topo, for the awesome presentations. I'm going to ask question to Professor Topo. It's very sad, Prof, to know that there are a lot of misuse in regard to mitigation fund for COVID-19. I also agree with what you said, your statement that we have to strengthen not only the panel policy, but also as the most important part, the non-panel policy, the preventions. As we know that one of the cause of the corruptions in regard to COVID is because of the government doing the discretions. Therefore, I think we have to make like stronger guidance or rule to discretion itself. So, however, that's not, I think, what the government think, because after I'm looking at the law number 11, 2020, instead of giving like guidance to the discretions, the government, they open like wider opportunity or wider doors for the discretion by deleting one of the important requirement of the discretions, which is it should be not breaching any existing law. So my question is, what do you think in regards to this government action, particularly the law number 11, 2020, whether it's in line with what is actually suggested by UNCIC and the other countries in the world? Thank you very much.
Professor Topo, would you like to answer that?
Okay. Okay, thank you for the question. Very interesting question from Melinda. So my, like, this is also the concern of many observers of Indonesian criminal justice system, not only disregard on the COVID-19 funds, the mitigation funds, but also in any other area. So I agree with you that I think the government mostly focusing on the economic and also focusing on the any other area related to economics and also on the health crisis and social crisis. But with regard to the law enforcement of the corruption, which the corruption itself always follow the, the potential in the procurement, which we know exactly that there are big amount of money related to the procurement system in this crisis situation. So I think the government need to give more focus on the discretion, the monitoring of discretion, the accountability of every government staff, every government pejabat pemerintah, every government officials who make discretions. So the monitoring, the accountability, and also the law enforcement if the officials itself commit corruption cases in this regard. So not only give a discretions from based on the regulation, law and regulations, but also give focus on the monitoring of the discretion, and also the reporting, the accountability, and law enforcement also. Okay, that's my opinion, Ibu Melinda. So I agree with you, your concern also. Thank you, Bu Moderator.
Okay, thank you, Professor Topo. Is there any questions, any other questions for Professor Topo regarding this topic?
Participant.
Yes.
Yeah.
From the audience.
Okay, thank you for the opportunity. So my question is, during the pandemic, there are a lot of government programs as a way to address or decrease the spread of COVID-19. And one of the programs is the distribution of masks or masker. And however, there is one of the candidates of regional election that utilized this program, the government program, as his personal campaign. Normally, this practice is included as a general election violation. However, since we are in the middle of the pandemic era, can we categorize this action as an act of corruption on the disaster fund? That will be my question. Thank you.
Okay. Can I respond directly?
Yes.
Yeah. Unfortunately, I could 100% hear very clear about the question, but I can grab the main idea of the questions. If I'm not mistaken, this related to the elections, the regional or the Pilkada, right? The corruption related to Pilkada. The COVID-19 mitigation funds related to Pilkada to 20 and 20. If that the main questions idea, I would mention that this is kind of what's so-called political corruptions. So political corruption also related to the use of power by any incumbent head of regional, head of province, head of kabupaten kota, or the governor or the bupati, who use illegally his power, yeah, corruptly, using the mitigation funds, using the social safety net funds or bansos to improve his or her popularity to the public in his province or his kabupaten kota municipality. So this kind of political corruption, and the law enforcement agency could use, like for example, the law on anti-corruptions, and also in certain case can use law on regional election, general elections, like undang-undang pilkada can also be used for certain offenses. But in my observations, the most area of the violation is related to the ethical violations used by the incumbent, yeah, in certain areas. Okay, that's my response of the questions. Thank you for the question.
Okay, thank you, Professor Topo. Is there any questions? Other questions?
Presenter still busy preparing the paper.
Yeah? Is there any? Okay, if there isn't any questions, I would only ask Professor Topo for another questions regarding this matter. As far as I'm concerned, according to the notes of Indonesian Corruption Watch, during the last 10 years, there were approximately 87 corruption cases of disaster management funds that have been proceeded by the Corruption of Eradication Commission. For the emergency reasons, millions on billions of rupiahs often discharged without clear supervision. For example, the disaster management funds for tsunami in Aceh has exceeded 150 billions, and the perpetrators, like you stated, were actually the government official and ministerial official or staff. As I read Article 2.2 on the law of 31 of 1919 about the eradication of corruption, even regulated a death penalty for the perpetrators of disaster funds. Ironically, even if with the rapid growth of the disaster fund corruption, up until now, as far as I am concerned, none of them are actually pleaded guilty or even to be sentenced to death. There was no deterrent effect because the average sentence is quite light. It's with just under 5 years of imprisonment. What do you think about this, Professor?
Yeah, thank you for very interesting questions. The Article 2, Section 2 or Paragraph 2 of the anti-corruption law provided the death penalty for the perpetrators if the corruptions related to the funds of emergency funds, for example, in this kind of situation like bencana alam and others situations. But until now, there is no single cases that provided the death penalty. I personally do not agree with death penalty because I am afraid of the situation in our criminal justice system. But I think severe punishment should be imposed to those who corrupt the emergency funds, like in this kind of situation, like funds for COVID-19 mitigations. I agree that the judge should impose a severe penalty, more severe than any corruption, because this is, of course, tidak manusiawi, inhuman offenses. Yeah, but there's a research conducted by my students, PhD students, that in several corruption cases, even though the corruption related to the emergency funds, but the judge do not impose the Article 2, Paragraph 2, but he used another provisions, yeah, instead of that section. Yeah, thank you.
Yes, thank you very much for Professor Topo. Okay, if there isn't any other questions, I would like to say thank you very much for all the presenters for their informative and interesting talk. Very well, ladies and gentlemen, now we come to an end of the presentation. We would like to say thank you again for the presenters and the audience for your active participation. Hopefully, the presentation will be beneficial for everybody. Thank you for your attention. Good afternoon.
Thank you, and good luck for all presenters, and thank you for Fakultas Hukum Universitas Hasanuddin. Bye.
Oh, thank you.
Prof. Topo.
Your Excellencies, ladies and gentlemen, thank you very much for Professor Dr. Santoso is M.Hum from University of Indonesia and Professor Dr. Eddy Hiariej as M.Hum from Gadjah University for the informative and insightful presentation, and also for Mrs. Aries as Damos moderating discussion for today. And Your Excellencies, ladies and gentlemen, these are the agendas that we have presented to you this afternoon, and coming up to the last session, we are going to have parallel session. For those who join the parallel session, please be noted that our session will start at 2 o'clock Makassar time and 1 o'clock Jakarta time, sorry. And please be noted after the break and lunch you already proceed to your presentation room. Thank you.
Mrs. Imelda SHMA, as well as a lecturer from Faculty of Law of Hasanuddin University. For Mrs. Imelda SHMA, please, the floor is yours.
Thank you, Master of Ceremony. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon for all the presenters and then participants who still here in our last plenary session, and also good morning for my best friend, my old friend, Dr. Khanyisela Moyo. Can you hear me?
Yeah, the audio is not so good.
Is it good? Is it clear? Can you hear me?
It's not very clear.
Okay. Once again, good morning, because yeah, we know that CEO is still in the morning, yeah, in UK.
Yes, it's in the morning.
Okay, can you hear me now clearly?
Yes, I can hear you.
Yeah. So happy to see you again, Dr. Moyo, Kani. How are you?
I'm fine, thanks. I'm happy to see you too.
Yes, it's so long, yeah. Yeah, to inform to all the presenters, the participants, Dr. Khanyisela Moyo is my old friend. We went together to the master program in Oslo University, and then since we're separate 17 years ago, now we meet again, even virtual. So happy, I'm so happy, and thank you very much, Kani, for ready to join us this afternoon in Indonesian time. Yeah, before we start the meeting, let me introduce to the audience, to the all the participants, the curriculum of the Dr. Khanyisela Moyo. Yeah, full name is Dr. Khanyisela Moyo, citizen British, education is Ph.D. in Law, Ulster University in 2009, LM.M. in Public International Law, University of Nottingham, 2004,
Okay, thank you very much, Chad. So the title of my presentation is Interdependence of Human Rights and COVID-19.
We already share your paper presentation, so you may continue speak.
Yeah, I'm trying to scroll to the next slide here. Okay, so in order to try and understand the relationship between human rights and COVID-19, we'll talk about rights themselves. What are they? When we talk about rights, we're talking about values or standards which are inalienable. That is, they cannot be taken away and given to someone else, and they're fundamental rights, a core and necessary base of central importance. Rights are based on values such as dignity and worthy of people. There are different types of rights. I'm saying the obvious as a way of introduction. You have civil and political rights, which rights ensure one's ability to participate in the civil and political life of society without discrimination or repression. Examples of civil rights will include the right to vote, the right to a fair trial, and the right to life. Then you have economic, social, and cultural rights, which include the right to adequate food, to adequate housing, to education, to health, to social security, to take part in cultural life, to water and sanitation, and to work. Then you have the right to development. The right to development is an inalienable human right by virtue of which every human person and all peoples are entitled to participate in, contribute to, and enjoy economic, social, cultural, and political development in which all human rights and fundamental freedoms can be fully realized. So historically, there used to be this talk of the so-called first, second, and third generation of rights. So first, representing civil and political rights, second, representing socio-economic, and third, representing development, the rights to ethnic minorities, self-determination, and so on. But as I said, this is an old-fashioned way of looking at rights. the new understanding now, which came from the UN General Assembly and the Vienna Declaration, is that rights are now universal. That is, they exist everywhere. They're interdependence. That is, they depend on each other. They're interrelated and indivisible. Indivisible meaning that they cannot be divided into equal parts or split. So the new understanding now is that there's no hierarchy of rights. But while you still have opposing and dissident views that still consider economic, social, and cultural rights to be aspirational principles. But as we know now, the new understandings that rights are universal, interdependent, interrelated, and indivisible. In this presentation, I'll be focusing on how COVID has confirmed the interdependence of rights. So COVID has confirmed that the rights that we have depend on each other. So my presentation is in 3 parts. I'll look at economic, civil, and political rights and COVID, and move on to look at economic, social, and cultural rights and COVID, and then the interdependence of rights. So in terms of the rights that are implicated in COVID, the first right to think about is the right to life, which is enshrined in Article 6 of the International Covenant of Civil and Political Rights, Article 10 of the UN Covenant on the Rights of People with Disabilities, and Article 6 on the UN Convention on the Rights of the Child. So we are combating COVID-19 to protect the lives of all human beings. Invoking the right to life reminds us that all states have a duty to protect human life, including by addressing the general conditions in society that give rise to direct threats to life. So the states currently are making extraordinary efforts to do this, and it is the primary focus of most states. So it is the right to life and the duty to protect life, which is enshrined in all these covenants that I have just cited. And then you have freedom of opinion and expression, which is enshrined in Article 19 of the Universal Declaration of Human Rights and Article 19 of the International Convention on Civil and Political Rights. Freedom of expression and opinion is very important in any democratic society. The focus which relates to COVID is how communication and dissemination of information relating to the views, to the virus and the circulation has been circulated. However, there have been worrying restrictions by states on the freedom of expression introduced by some states. And of course, rumors, misinformation, and disinformation are harmful to public order and health safety. So there's a need for states to jump in and enforce and include restrictions. However, this should be balanced with the right for journalists to scrutinize government's response to the crisis. An example that we have of this difficulty with freedom of expression and opinion with regards to the virus is the Chinese state's persecution of whistleblowers, Dr. Li Wenliang, who was persecuted by the Chinese state. That's the example that we have of the difficulty in trying to balance freedom of expression and opinion and the need to deal with conspiracy theories, false information and so on, false alerts and so on. How do we balance that with good information that is necessary to scrutinize government's response to the crisis? And of course, we have freedom of movement, which is enshrined in Article 12 of the International Covenant of Civil and Political Rights. So you have all these lockdowns that are there, that are capping freedom of movement, and what does the law say about them? So you also have the right to vote, which is enshrined in the International Covenant on Civil and Political Rights. It so happened that a number of states are holding elections in 2020, and the right to vote being a democratic right. As I said, the right to vote is enshrined in the ICCPR Article 25. While many countries have put special measures in place to enable people with COVID-19 and those self-isolating to vote, some, including Belize and Zimbabwe, have made it difficult for them to do so. For example, in Zimbabwe, they've just suspended all elections, thereby violating the right to vote. Next slide. And then you have the right to health that is enshrined in Article 12 of the International Covenant on Economic, Social, and Cultural Rights, and Article 12 of the Covenant on the Elimination of Discrimination Against Women, and Article 5 of the Covenant on the Elimination of Racial Discrimination. The right to health is just an obvious one. So that state have been trying to facilitate and this continuous search for a vaccine. Without a vaccine, can we really talk about the right to the highest standard of attainable health? That's a moot question. And then we have the right to education. In the beginning of the year, most states closed schools and then made arrangements for homeschooling. However, in Africa, for example, access to education is favoring the digitally literate and privileged. Even in the UK, a fairly wealthy country, we have a problem of access to education because in the first, before the schools closed, parents were supposed to homeschool their children. And the UK government was being sued because of lack of internet and devices for poor children. So access to education becomes a serious issue when it comes to COVID, because those with resources will be able to learn remotely using devices and the internet, but those with digital challenges then face the problem of not having access to education. But access to education remains a right which is enshrined in the Universal Declaration of Human Rights in Article 13 and 14 of the International Covenant on Economic, Social, and Cultural Rights. And of course, these rights are not absolute. Human rights law recognizes that national emergencies may require limits to be placed on the exercise of certain human rights. If we read Article 4 of the International Covenant on Civil and Political Rights, it aptly states that in times of public emergency, which threatens the life of the nation and the existence which is officially proclaimed, the state parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with their obligations under international law and do not involve discrimination solely on the grounds of race, color, sex, language, religion, or social origin. So restrictions are permissible. However, Article 4 of the International Covenant on Civil and Political Rights states that no derogations should be made from Articles 6, 7, 8, 11, 15, 16, and 18. And Article 6 is on the right to life. So this is an absolute right. Even in times of COVID, you cannot derogate from the right to life. And Article 7 is freedom from torture, inhuman and degrading punishment. So it means that even in times of the epidemic or pandemic like COVID, one cannot derogate from torture, inhuman and degrading punishment. States should not torture or punish people. Even those who are spreading conspiracy theories may not be punished or tortured. And Article 8, no one shall be held in slavery and slave trade in all their forms shall be prohibited. So even though there's an economic crisis, people should be paid for their work. They should not be held in slavery. And then you have Article 11, which says that no one shall be imprisoned merely on the grounds of inability to fulfill a contractual obligation. Again, they cannot derogate from this right. And then Article 15, no one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national or international law at the time when it was committed. So this is the prohibition against retrospectivity of the law, which is a cornerstone of the rule of law. And you cannot derogate from that even in times of the pandemic. And then Article 16, everyone shall have the right to recognition everywhere as a person before the law. Again, you cannot derogate from that one. People should continue to be recognized as people before the law. And Article 18, finally, states that everyone shall have the right to freedom of thought, conscience, and religion. So states should not derogate against those rights, even in terms of the pandemic. It's not only the ICCPR that contains a limitation clause. Article 4 of the International Covenant on Economic, Social, and Cultural Rights also contains limitation on rights. The state parties to the present covenant recognize that in the enjoyment of those rights provided by the state in conformity with the present covenant, the state may subject such rights only to such limitations as are determined by law, only so far as this may be compatible with the nature of these rights and solely for the purpose of promoting the general welfare in a democratic society. So, even though there are limitations, these limitations are supposed to be proportionate, measured, and rooted in science and the law. So we've discussed the rights that we've discussed the rights that are implicated when it comes to COVID, and I've also looked at the limitations of those rights. Now move on to look at the interdependence of rights and COVID-19. The first one to think of is the right to life and the right to health. So when you talk about the right to health in the context of COVID, you're talking about the right to health and access to health care. The right to health is inherent to the right to life. So you see this connection there, the dependence between the right to health and the right to life. COVID-19 is testing the limits of states' ability to protect the right to health. Every human being is entitled to the enjoyment of the highest attainable standard of health, conducive to the living a life in dignity. Everyone, regardless of their social or economic status, should have access to the healthcare they need. But their interdependence is there with the right to life. You are protecting the right to health so that people may not die, for example, to reduce the number of people who are dying or to prevent deaths. So there is that interdependence between the right to health and the right to life. And violations of the right to health impairs the enjoyment of other human rights, such as the right to education and work. So if people are unwell, they'll not be able to go to work. they will not be able to attend school and so on. And also there's a nexus between the right to health and the right to water, sanitation, and etc. The advice that they've been giving to people during the pandemic is that people should continuously wash their hands. But in contexts and in countries where they have no running water, how do they wash their hands? How do they maintain good hygiene and sanitation? So these are the challenges that have been brought forth by COVID, which demonstrates the interdependence of rights. So even though the key rights that are involved are the right to life, the right to health, and freedom of movement, we still have challenges with regards to all the other rights that are not expressly mentioned. For example, the right to education and work, and the right to water, sanitation, and so on. As I've said before, there's also a nexus between freedom of speech, which is a civil and political right, and right to health, which is an economic, social, and cultural right. Conspiracy theories are potentially harmful, for example, to the realization of the right to health. And how about freedom of movement and the right to education? Travel restrictions have made it difficult for citizens to get to work, school, or to visit their loved ones. And because of freedom of movement challenges, because of these lockdowns that have been imposed, many people have found themselves out of work. In the UK, for example, many people have found themselves to be reliant on food banks, which are really donations of food from well-wishers. And this has been very problematic because some of the food that have been donated does not comply with the cultural requirements of certain people. So that has been a violation of the right to food. So how do we then talk about the nature of a state's obligation to protect, to respect, and to fulfill the right to food? All these obligations seem to be at stake. So from what I have said so far, COVID has demonstrated.
Dr. Moyo, I remind you the time is only 20 minutes. Maybe you can make it conclude. Sorry, you already used 20 minutes, so we remind you. I remind you again. I'm sorry.
Thank you. I'll just conclude. To conclude, COVID has confirmed that human rights are indivisible, interrelated, and interdependent. We can no longer talk about first generation of rights or second generation of rights or third generation of rights. It has shown that these rights apply in equal footing. There's no hierarchy of rights. Thank you very much.
Thank you, Dr. Moyo, for the Yes, we still have a time for questions and answers for the session. 1 minute. One person. One question. Okay. I know that many participants would like to deliver question to Dr. Moyo, but since we have a limited time, we apologize for this. It's running night now. So only one person. I give a chance to one person to deliver a question to the participant. Yeah. Yeah. Dr. Moyo is so far away, yeah, from UK, so we have to use the possibility to have a discuss a little bit more about the COVID and 19, COVID and human rights. There are 3 parts of discuss from Dr. Moyo. Is it ICCPR and COVID, ICACR and COVID, and then interdependence of rights and COVID. I saw there's one person. Yeah, Detania Gadjah. I saw you raise your hand.
Yeah, thank you. Thank you very much. I would like to ask Ms. Moyo's opinion on the debate whether the government's act or policy limiting people's movement, that kind of policy which limits people movement, making people staying at home, actually contradicts their human rights to go outside, to work, to make a living and all. So I think it's an ongoing debate, not just in Indonesia, but also elsewhere in around the world. So I would like to know what your position on that. Thank you very much.
Thank you.
Yes, thank you very much. If we talk about freedom of movement, it is an internationally enshrined right. It is enshrined in the International Covenant of Civil and Political Rights. However, this right is not absolute. Government can take urgent measures to curb the spread and to safeguard public health and for the people. So in an effort to safeguard public health, government is within its rights to restrict freedom of movement. Of course, the restrictions should be proportionate, measured, and rooted in science and the law. But this is not an absolute right. The covenant itself allows the government to restrict those rights in situations of emergency.
Thank you.
Thank you, Dr. Moyo. Do we still have time for another question? To all participants, I'm sorry to inform you that we have to close this session. It's very interesting to discuss with you, Kani, but since we have only limited time, so I have to end the session. Thank you very much for your time. I know it's early in the morning, and then you spend your time. Try to put your session in line of our session for today. Before I return to Master of Ceremony, I will close this session with quote from the Secretary General of the United Nations, Antonio Guterres. Human rights response can help with the pandemic. By respecting human rights in this time of crisis, we will build more effective and inclusive solutions for the emergency of today and the recovery tomorrow. Thank you very much, everyone, for attending the session. Thank you very much, Annie.
Thank you.
Thank you very much. Once again, big applause to Annie. Thank you very much. And I return back to the Master of Ceremony.
Okay, thank you for Mrs. Inkaita Sakariman Sakari. And also, thank you very much for Dr. Khanyisela Moyo from Ulster University for an informative and insightful presentation. Your Excellencies, ladies and gentlemen, these are the events that we have listened to you this morning. And coming on to the last session, closing ceremony.
Assalamualaikum warahmatullahi wabarakatuh.
Good afternoon.
Shalom.
Om Swastiastu.
Namo Buddhaya.
First of all, let us pray to Allah Subhanahu wa Ta'ala, the Almighty God, for His mercy, blessings, and guidance, so we are able to attend this closing ceremony of Second International Conference on the track, Business, Human Rights, and Globalization with the global problems in COVID-19 outbreaks and its solution.
The next agenda is closing speech from the chairman of the organizing committee, and afterward, we would like to request the chairman of the organizing committee to officially close the international conference from Mr. Dr. Rector, SH, M.Hum, LLM. Please
The floor is yours.
Good afternoon, ladies and gentlemen. The Honorable was the for students, university and alumni, and the distinguished invited speaker who still left, Dr. Khanyisela Moyo, and all participants who still stay in the room, and all the organizing committee. Yeah. First of all, on behalf of the Dean of Faculty of Law at the University, we apologize. Actually, the Dean is scheduled to close this conference. However, due to she is not in well condition, she asked me to represent her to close this conference. And please allow me to read the closing remark for the Dean of Faculty of Law, Hasanuddin University. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. On behalf of the Faculty of Law of Hasanuddin University, I warmly welcome you all to this conference. It is a great honor for us to host this international conference and to exchange views with distinguished speakers, presenters, and participants. The theme of this year's conference is legal problem in COVID-19 outbreaks and its solution. We are aware that this pandemic has affected many aspects of people's life, including legal matters. Therefore, we chose this topic with hope that we can exchange views and perspectives related to these legal issues and find prospective solutions. This is the second year we host this international conference. And due to the current pandemic situation, this year we carried the conference virtually, unlike the first one. It is quite a challenge for all of us to adapt with the new trend. However, I feel satisfied that we can get through it and finally be able to conduct a successful conference. I would like to send my gratitude and thank all our invited speakers for attending our conference and for delivering their presentations virtually, despite some obstacles like distance and time differences. My appreciation also goes to all the presenters and participants for attending this conference from the beginning till the end from their respective places. I would also like to thank our Rector and Vice Rector for always supporting our activities in Law Faculty, including this conference. In addition, I would like to thank Vice Deans and staffs of Law Faculty for their support and cooperation during the implementation of this conference. Last but not least, thank you for the hard work of the committee and students for making these things possible, and for organizing this conference successfully. Finally, I do hope that this conference could become a great platform to exchange ideas and expand our knowledge in the field of law, and we can take advantage of this opportunity to build and strengthen cooperation and networking among us. I wish you all had a very successful conference, and to conclude, let me close this conference with hamdallah and gratitude. I hope this conference can be held again next year and we can meet again. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.
Waalaikumsalam.
Atau mau dipotong di kemarin angka Pak S 250 KWH, kan nanti bisa jadi itu best.
Thank you for Mr. Dr. Universitas M.Hum as the chairman of the organizing committee was officially closed this conference for this afternoon. Your Excellencies, ladies and gentlemen, these are the agendas that we have presented to you in this afternoon, and thank you for your participation on the closing ceremony of the second international conference on the track, business, human rights, and globalization. Thank you very much.
I'm Aulia Delia Muhammad.
And I'm Dami. Wassalamualaikum warahmatullahi wabarakatuh. And see you on the next International Conference 2021.